Hi, Mr. Stigl.
The Human Rights Commission. Looks like.
Hello, Amy. It's Chandler and Michael.
Good morning, Mrs. Nearson.
Your camera is keeps freezing.
Oh, okay. Just do it on your.
Good morning. I just wanted to let you know I'll be keeping this on mute, keeping you on mute until it's time for your case to be heard. And just so you know, your camera keeps freezing, just so you know.
Okay. Can you hear us now?
I can. Yep.
Yeah.
Okay. Good morning. I have just a few questions, Amy. I wanted to
Is
know.
it about this? Well, hold on. Is it about this case today or
No,
about?
no,
Nope,
no,
then don't ask me. If it's about another case, please don't ask me right now.
No, ma'am. I
Okay.
understand rules. Thank you. I know, and I understand legal etiquette. I wanted to know how many people are going to be attending this meeting.
I don't know off the top of my head. We sent you an updated agenda. There are 4 cases being heard this morning. So there'll probably be at least 8 people plus staff and our commissioners. But it is, we're streaming this on YouTube because it's open to the public.
Yep, and I'm prepared for that. I am more than ready. Yep.
Okay, great.
I actually got to watch you in action. I watched a couple of cases. I wanted to see how the process was virtually, so I learned a lot.
Good. Okay. Is there any other question about the process for today?
It's kind of, it feels like it's going to be sort of like a Q&A process where the contextual information in the original complaint is going to be, there's an opportunity for that information to be weighed in front of the commission, for the commission to go over the facts, the fundamental basic facts of the case, and put that up against the civil rights laws, like the laws that are supposed to protect people for equal opportunities when going to rent commercial properties. And I think, that's what I want to talk about when we get into this. And I want to talk about pretext, because pretext is going to be a big part of this case. So I'm thinking that's kind of how it's going to go back and forth like a volleyball.
It's really up to the commissioners. The way this works is you have 10 minutes to make a presentation. The other side has 10 minutes to make a presentation. The commissioners might ask you questions, they might not. They might ask the other side questions, they might not. So it might go back and forth or it might not. I don't know.
Okay. I have a greater understanding of kind of how this works and what your job is. It took me a while to understand your position, but I understand it a lot. I have a greater respect for it, and I understand it on a deeper level because I have a aunt that is a retired, not in the state of Maine, but state of Connecticut retired workers' comp commissioner. So, yeah, I understand.
Okay. Well, it's great to see you this morning. Just so you know, I'll be keeping you and Mr. Stigl and if you're right next to each other, just be careful you don't get feedback if you both have your audio on at the same time. But for now, I'm gonna keep you on mute. And if when the other side shows up, any case that's not being heard stays on mute. And then I'll
Okay.
unmute you or ask you to unmute yourself when it's time for your hearing.
Yeah, what time? They said 8:30, but does it go? It just depends on everything.
Yeah, it could be, for all I know, every case before yours doesn't show up and you'll be the first one, but more likely, each of those cases will show up. And I suspect both of the cases that are on the agenda before yours will show up, and they will be hearings that will take at least half an hour each, maybe more. So
Okay.
that's the best I can do to guess.
And then
But
question: I seen you in a commercial for COVID-19 discrimination, and there is a African American man that I know. I forget his name. He's part of the DEI committee. Do you know his name?
I forgot his name. He does work with the basketball team. The Red Claws. I forgot his name.
Yeah, really nice guy though. Yeah.
I've actually never met him. He volunteered to do that because he knew the people who were making the public service announcement. So they asked him to do it.
Oh, okay.
Which was super nice of him.
Yeah. I liked the video. I didn't realize that I didn't realize that they use some of the funding to educate people as well.
We try.
Yeah.
We try. Yeah.
Okay.
Right.
Well, we'll talk. And just so you know, I want to say this to you. I'm going to be respectful of you in the process.
I appreciate that, but I appreciate you telling me that. And I know that you're here for all the right reasons, but please know lots of people have nice things to say. Lots of people have some respectful things to say. Lots of people don't, and that's okay. Whatever you want to do to present your case, as long as it's within our rules, is up to you. But I appreciate you saying that.
Yeah. Okay. Thank you, Amy.
All right. Thank you. Are you Mr. Stigl? Nope, that's Mr. Stigl. Are you Mr. Dixon? All right. So Mr. Dixon is the young man. Mr. Stigl is the extremely young man.
Yeah. I'm learning.
Almost went terribly wrong there, but yes, it's nice to meet you both after seeing your names on the pleadings.
Yeah. Thank you.
Okay. Hi, Mr. Moody. Could you just let me know what case you're here for?
Yes, ma'am. The MSAD 54 case.
Great.
Thank you.
Thank you. Good morning, Ms. Fagan. Just
Good
want to let you
morning.
know, good morning. Just want to let you know that I'll keep you on mute until it's time for your case, okay?
Okay.
Thank you. Good morning, Commissioner O'Brien, and what I have to assume is Mr. O'Brien, Mayor O'Brien.
Oh, you do know that.
You do, yes. Congratulations,
Thank you very much.
and nice to meet you.
Same as that, Amy, Mark.
Thank you.
Same old that he's been for 35 years.
You want this background blocked?
Yes. No, it's all right. It's all right.
Commissioner, do you prefer me to put Julie Ann O'Brien or just Julie O'Brien? Nope, you're muted now.
Julie's fine.
Okay.
Thanks. So Amy, I,
Yes.
you probably know, but they've scheduled me before the judiciary.
Did they
committee.
actually give you a date?
Yeah, the 20th.
Okay, when I talked to the clerk last week, they were bouncing around a bunch of dates. They have a lot of confirmation hearings. Okay, that's good to know. I did
20th,
not,
20th at 9.
20th at 9. All
Yeah.
right. It was on my, you were on my agenda of things to mention, 20th at 9.
Yeah, and as I understand it, they'll just submit everything that was before, and unless somebody in the last 8 months doesn't like the way I voted.
Which I'm sure is true. I'm sure there's some
Yeah.
case, I'm sure.
Yes.
Yeah, it should be pretty pro forma, especially since you were just confirmed the
Okay.
first time recently. I don't
Yeah.
expect there'll be anything much happening.
Okay,
Thanks for telling me.
yeah.
Good morning, Ms. Bucksbaum. Yep, I'm going to keep you on mute till it's time for your hearing. Thanks. Morning, Commissioner Whitworth.
Good morning. I'm going to put myself on mute.
Good morning, Barbara. I can see your faces. Oh, where'd you go? Did you just turn your screen off? Oh, you disappeared. Oh, well. Trying again.
I think I got it this time.
Good morning, Mr. Swanson. I'll keep you on mute till it's time for your hearing.
Okay, good morning.
Morning. Good morning, Commissioner Ashby.
Good morning. How are you?
Good, how are you?
I'm okay.
Good. You could do worse, right? These days I will take okay.
I'm a little out of breath. I didn't expect to have to snow blow my driveway this morning, and I had to do it the last second before this meeting.
Oh, did you get a lot of snow up there?
No, but I got enough to snow blow, so just enough. Just that irritating amount that you can't leave on the ground.
Just enough to block the end of your driveway, right? Good morning, Commissioner David.
Hello, test. Hello, test.
We can hear you. morning, Ms. Tunick. We'll keep you, and I'm sorry, I'm sure I pronounced your name wrong. We'll keep you muted till your case is heard.
Amy, do you know if everybody's here who needs to be here?
Yeah, we have enough commissioners for a quorum. So I don't see the complainant for the first case or the investigator, but we still have 15 minutes for that.
Sorry, I'm sorry, Amy, my speaker was down. Can you repeat that? I'm sorry.
Oh, it's fine. We have enough commissioners for a quorum. I
Okay.
don't see the folks for the first case, but we still have 15 minutes for that.
Okay, all right. Well then, it's 8:30, so let's get started. Good morning. I'm Deb Whitworth, and on behalf of my fellow commissioners, welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, I think we probably all do, cell phone, pager, etc., to ensure that they're silenced now. You have received a link for an agenda, including the consent agenda. And the consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted time. The commissioners will vote on those cases and they will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. And as I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments to the case. The time is limited to 10 minutes, and time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Before that, however, we will go to our business session and look for an adoption of the agenda and consent agenda.
Move for the adoption of the agenda and the consent agenda.
Second.
And
So
Amy, I'll let you
commissioners-
do your thing with the vote.
Yes, commissioners, as a reminder that when we're doing remote meetings pursuant to Maine statute, I'm required to have each of you vote so that someone attending can both see your vote and hear it. So I need you to raise your hand and also say your vote. Good morning, Commissioner Doosan. We are voting to adopt the agenda and consent agenda. There's a motion and a second, and so I will go down the roster in order of seniority on the commission to see your vote on the pending motion. So to adopt the agenda and consent agenda, Commissioner Whitworth,
Yes,
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Doosan,
Yes.
Commissioner O'Brien.
yes,
Thank you.
and now the minutes from our December 13th, 2021 commission meeting. Is there a motion to adopt or revise?
Move adoption.
Second.
So it's been moved and seconded to adopt the minutes from December 13's meeting. If you vote yes, you're in agreement. Commissioner Whitworth,
Yes,
Commissioner Ashby,
Yes.
Commissioner O'David,
Yes.
Commissioner Doosan,
Yes.
Commissioner O'Brien.
yes,
Thank you.
and now if we could have a director's report. Amy?
Yes, good morning. Let's see. First, Happy New Year. Second, you have a personnel report from me. We have on here a new investigator. This is her first commission meeting. Where'd she go? Courtney Byrne is on here. Welcome to Courtney. We're not going to make you do anything, just wanted to welcome you. And I did mention in my memo to you, there she is. Hi, Courtney. Coming soon to a meeting near you, that we are extremely short-staffed to the point where I actually emailed the lawyers who frequently practice at the commission to tell them to understand that there will likely be delays in processing because we're so short-staffed. There's a thing on our website, and I think I've shared that all with you recently. For compliance, you have a memo that shows that there are 7 cases pending in conciliation. 4 cases finished the conciliation period without successful conciliation, so failed. There are not any successful conciliation agreements to present to you today, as far as I know. New charges, we received 69 of them in December. Administrative dismissals, well, I'll skip that one for a second. We don't have a report on that anymore that we can send you because our system doesn't create that anymore. So we get them from looking at our resolutions report. You all get a 1-page report that just shows a total number of different types. So for predetermination settlements, there were 16 of them in December with benefits of about $432,000 to complainants. What doesn't show on here is administrative dismissals, because I'm the one entering those now, along with all the other closures. And we did, I think I closed 61 cases in December. About 10 of those were administrative dismissals, but I just haven't gotten to put them in the system yet. So we are doing ADs, they just haven't gotten put in the system yet. Quarterly reports, because it's a quarterly meeting, we're reporting on the quarter that ended December 31. And so in that quarter, we did 13. You have a report showing that staff, commission staff did or attended, offered or attended 13 training or outreach events. Our case inventory is creeping up in a way that is uncomfortable, but it's going to happen for a while. There's about 817 cases pending as of December 31st. And if there is not a finance report uploaded, there will be one provided to you shortly. Litigation, I would ask that we take after executive session. For new business, the big news is that the legislature is now in session as of the 5th. The first thing is Commissioner O'Brien, who was appointed towards the end of the seat that she sits in. She was appointed and confirmed towards the end of that, is that she's been reappointed, which is great. And she let me know this morning that her hearing is on the 20th at 9 in the morning, and I will be there virtually. Everything is virtual this session. So in terms of other legislative things, this is the short session. This is typically only for emergency matters and the supplemental budget. We have one bill, one agency bill that's been introduced to clarify the scope. I don't remember the actual title, but it relates to the Whistleblower Protection Act and Maine Supreme Judicial Court decision that came down strenuously limiting the availability of Whistleblower Protection Act remedies to employees who are in unionized workplaces. So we have a bill which does now have an LD number 1889. I just found that on Friday. But nothing is set for hearing yet. They're just getting now to scheduling hearings at judiciary. We will also have hearings. There's a hearing in the long-suffering Equal Rights Amendment that's been introduced over and over and over and over and over again, which is not our bill, but we will be testifying. There's also a bill, LD 982, that's a carryover from last session about amending the provisions relating to public entities under the Maine Human Rights Act with regard to what areas of jurisdiction or what protected classes are covered with respect to public entities. That's not our bill, but we are providing testimony and support, as that is something that we have actually introduced in the past. There's also another bill, 1871, to extend a pilot project that our agency started doing about 2 years ago related to receiving complaints on the basis of homelessness. Because that bill went into effect right as the pandemic hit, there was really very little opportunity to get the types of complaints and reporting that we want to be doing to the legislature. So there's a bill in to extend that pilot project by 2 years. And finally, we will be, I think I sent commissioners a copy of our very voluminous Government Oversight Act report in November. It's a statutorily required report that we have managed to avoid having to do for quite a while, but now we had to do it. And apparently what goes with that is a hearing presenting our report to judiciary, which we will apparently have probably either next week or the week after. So when I find out when that is, I will share that information with you. And that's all I have for new business.
Okay, let me get back to my agenda here. Hang on just a moment.
Sure.
So with being done with our new business, we can take a 5-minute break and we'll reconvene at 8:45 and hear our cases to be voted on.
Thank you.
Okay, it's 8:45, so let's get back and hear our cases to be voted on. As I said just a few minutes ago, cases will be called in the order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions, and please introduce yourself when you are called to present your case. And our first case is ED/PA 20-0095AB, Andy Barasa, individually and on behalf of minor child, the MSAD 54 and MSAD 54 school board. Is there anybody here? This is a reasonable grounds recommendation. Is there anybody here for the respondent?
Yes, I'm here. Campbell Badger on behalf of the school district.
Okay, you have 10 minutes, Mr. Badger.
Thank you. Thank you for giving me this opportunity. The investigator found reasonable grounds for believing that MSAD 54 discriminated against complainant because of her sexual orientation by perpetrating a hostile hostile educational environment. The investigator based his decision on 5 events that are outlined in his report. The school district asserts that the investigator erred both in the standard of law to establish liability on the school district's part for a hostile educational environment, and also that the factual conclusions that the investigator drew do not support that standard of law that he applied, regardless of which standard of law is the appropriate standard. We also would like to suggest that the investigator was factually incorrect in some of his findings that were not supported at all by the record, and that he relied upon events that occurred outside the 30-day statute of limitations and therefore should not have been considered. So the first concern has to do with what the standard of law that the investigator applied. And our concerns are limited exclusively to, or almost exclusively to, the report that the investigation report that that was submitted on December 1st. On page 5, the investigator states, to establish liability on the part of a school for hostile environment, the complainant must demonstrate that the respondent knew or should have known of the facts, known of the harassment, and failed to implement prompt and appropriate action. This is a standard taken from the employment context. It's the incorrect standard to apply within schools, because it assumes that school districts have the same control over the third-party actors, students, and others as an employer has in the workplace. An employer does not have that control. Instead, the main human rights should have applied the same standard as followed in Title IX. Schools have action, and that standard is schools have actual notice of the harassment, and the school's response must amount to deliberate indifference to the discrimination. This case, the appropriate standard was considered in the case of Doe versus Clichy, and the court rejected the knew or should have known standard and the failure to take prompt appropriate action. In our brief, we've cited that case as that's the appropriate case. I know that in a memorandum of or or a memorandum that the Maine Human Rights issued. They've suggested that it's the higher, more exacting standard, but the Superior Court has taken the approach that schools should be provided a greater degree of flexibility, and that courts should not interfere with or second guess the actions taken by a school districts. So that's the first concern, is that the investigator applied the wrong standard. But even if, regardless of the standard that the investigator applied, in this case, the 5 events that the investigator relies upon to find a reasonable basis for believing that discrimination occurred, they don't support that conclusion. So I want to go over those 5 events that the investigator relied upon. So there was one event where teachers' comments. A teacher stated to the complainant, a high school student, that he would not place a safe place sticker, a sticker showing that this would be a safe place for students, on his classroom door. And he further told the student that while he would tolerate all students, he would not personally accept certain religious, political, or social beliefs. Now, there's no question that that's incorrect. There's absolutely no question that that's incorrect at all. But I'd suggest to you that these occurred, well, I'm not suggest, it's in the record that these comments occurred on October of 2017, well outside the statute of limitations. The investigator in his report is factually incorrect. He states that the teacher pulled the high school student out of her classroom. Nothing of that sort occurred. This was an interchange between the student and the teacher when the student approached the teacher asking to place a safe place sticker on his door. And then when the superintendent learned of this, some 200 days later, in May 30th of 2019, at that time it was the assistant superintendent, now he's the superintendent, but he was also the affirmative action officer at that time. When he learned of this through a meeting with the student and other students, he actually confronted the teacher and told him that it was his job to accept all students and not just tolerate them. Now, most importantly, on page 5 of the report, this is page 5 of the report, this is what's written. The investigator also notes that upon learning of the alleged conversation, the school met with the teacher to convey that the conversation was inappropriate and inconsistent with school policies. And then he found, most importantly, an immediate and appropriate response. So regardless of the standard that what's the appropriate standard, even if we accept the higher standard that a school district must take immediate and appropriate response, the investigator in fact found that the school district took immediate and appropriate response. The investigator then reached a conclusion that the fact that the teacher would make a statement is evidence that the school district training was inadequate or ineffectual. And that's an entirely, first of all, there's no basis for drawing those conclusions. There was no allegation that the training provided by the school district was inadequate at all. But that's not the standard that is applied either by the Maine Human Rights Commission or by the higher standard, because what it is it's being put on notice that something occurred and then taking immediate effective action, not whether the school district in any way contributed to the underlying discrimination by failing to train its employees. And also replete through the record is all the trainings that the school district provided, including consulting with the Attorney General's office and various other agencies as to what appropriate training should occur in the school district to promote a more inclusive school environment. The second instance that the investigator relied upon was an Instagram threat that occurred in April of 2019, so that it was within the statute of limitations. This was an anonymous post on Instagram. There was a vile posting. It was an offensive and contained homophobic language. But as the record shows, and as the investigator found, was the school conducted an immediate investigation. It interviewed all the students who liked the post. It contacted the Attorney General and the local police department. It contacted Instagram and got the post taken down. It consulted with the program director of Outmain. It contacted the Department of Education. It drafted a letter to students and parents. It consulted with the civil rights team and actually met with the civil rights team and the complainant in this case, and in the record on the complainant said the letter was quote unquote amazing. On page 6 of his report, the investigator found respondents' response to this incident appears to have been prompt and appropriate despite the inconclusiveness of their investigation. So here we have a second event upon which he found relied upon, even though to find a reasonable basis for discrimination, that in fact the school district did, in his own words, take prompt and appropriate measures. The third incident that the investigator relied upon is
Mr. Badger?
Yes.
I'm sorry. I'm sorry, I think I muted myself. That was, sorry to interrupt you, but that was your time.
Oh, no, that goes very fast.
It does, I know.
It went way too fast.
I know.
I'm going to, can I just say, can I just add something, Ms. Nearson, just in the report, if you look at the report, each of the submission that we found, you'll see that in each of the occasions that the investigator relied upon, he also concluded that
Mr. Badger, it kind of seems like you're continuing to present.
Okay, I'm sorry, I have no.
Okay, so now I'm going to see maybe one of the commissioners will have a follow-up. So commissioners, if any commissioner has a question for Mr. Badger at this point, please raise your hand. See one. Okay, Commissioner Ashby.
Good morning, Mr. Badger.
Mr. Ashby.
Am I correct to understand that your view of the hostile environment standard requires an analysis of the school's response to incidents that occur and not the incidents themselves?
Yes, that's the standard. That is the standard, because we don't actually, I mean, we have a series of, we have third parties actors here, and they're unlike our own employees where we can take, you know, we train them, we can control them, we can terminate them. Here, we do not have that control, the same degree of control, especially in this instance where there's no evidence, such as a third incident where the complainant received telephone messages on our phone. There's no suggestion that that was from students. So the question is you're going to have to look at is how the school district responded to these concerns and whether those responses were immediate and appropriate.
Right, you argued fairly convincingly about the duty of the school to respond appropriately, and your argument focuses on that. But is there room in a hostile environment analysis for a set of circumstances where the culture or environment of the educational setting is just so, I don't know, infected with?
Yeah, you know, I see your point, and I think perhaps, but that wasn't that was not being challenged here. And I think I mean, I don't want to foreclose that because I think that the school districts are under an obligation to ensure that all students feel included and welcome. And certainly in this case, I think the school district did. I think the record is replete with all the measures that it took. So I don't want to foreclose that because I think that the school district is under a heightened duty, or not a heightened duty, but it is under a duty to provide an inclusive educational environment.
Do you think, though, that that was what the investigator was getting at by making note of the sort of cumulative effect of the sort of fits and starts of the school that seemed to be, for this complainant, wholly ineffective? Do you think that might have been?
Well, I think I think he's going to have to take much further analysis to reach that. I mean, even if you look at the case that he cited from New Jersey, there's a much greater, and even the case that he cited in New Jersey, excuse me, that case inside, it didn't look upon the culture. That was not what the case is. And I'm not aware of any case which says under the Maine Human Rights or under Maine law or in the First Circuit, which says the school district actually is under a legal requirement to create an environment that is inclusive. I think that you could do that. That's not a legal standard that has been recognized by the courts in the educational environment.
So legal, from a legal sense, the hostility is the school's failure to take appropriate and necessary corrective action.
Absolutely. It's being put on because it doesn't have that same degree of control over students that you have in the workplace. And so that's the Title IX standard. And Title IX standard there's not that aiding and abetting standard, but a deliberate indifference standard.
Thank you, Attorney Badger.
Any other commissioner questions for Mr. Badger at this time? Seeing none. Thank you, Mr. Badger. So Commissioner Whitworth, I don't, if you want to call the complainant, I don't see their email or their name showing up yet, but maybe I'm wrong.
Is there anybody here for the complainant, Andy Barassa, individually and on behalf of minor child? Is there?
Yes, I'm here.
Oh, okay, great.
Okay, so Stacy, that is Mr. Barassa. Sorry about that.
That's okay.
Okay, so you will have 10 minutes.
Okay, I guess I will speak to the fact that I'm going to just go through and speak to the points that Attorney Badger spoke to. I'll start with the mace. If it's true that the Principal Bruce didn't specifically mention the mace, then why would we have dropped?
Sorry to interrupt you, and I'll pause your time.
Sure.
I forgot to remind all of the folks in this meeting to not use the names of any third parties or witnesses. The Maine Human Rights Act requires us to keep their identities confidential. So in our report, we give them a pseudonym like superintendent or principal. So thank you. Sorry, go ahead, Mr. Barassa.
Sure. So if it's true that the principal didn't specifically mention the mace in the case, then why would we have dropped the plan, the safety plan, and told them not to bother consulting with the insurance company any further? As we now had concerns about that being baiting our student into using the mace, which we had been advised by lawyers as well, that could be considered assault if that our student was to use the mace in an incident. So once that was kind of out in the public, we were pretty clear that was not a good plan of action. The mace which we had purchased was never even opened after this incident because of that had been specifically mentioned. Specifically, we had concerns over this very specific piece of information that was shared in front of very specific families that were suspected of committing the offenses in the community and in the school, which involves students and adults. In regards to the use of the F word, which was mentioned in the brief, it was used multiple times, the slur, more than 5 in more than one setting or pretense. The use was conversational in a manner of feeling out the sensitivity and appropriateness with a student he felt he had rapport with. He was essentially using Anna or my student as a token gay person to test the language on, not appropriate in a position of leadership and from the top model of the school in terms of authority. In terms of the safe space, there were 2 incidents with the teacher involved. One occurred after the presentation as stated by the student. A second incident did occur where the teacher chose to pull the student aside a second time in the middle of the gym period, pulled aside out of class. This was stated during the hearing to Attorney Badger and the investigator that there were 2 incidents. So essentially, I would argue that they're arguing the student is not telling the truth in both incidents of the situation with the principal and in the situation of the safe space. In regard to the Instagram post, the school did not get the post removed. It was stated to me by all administrators that they had no authority to contact Instagram and get the post removed. The post was removed by the original poster of the post, and that was what made it further and difficult for them to figure out who had done it, because it was removed before they could actually take action and try to further follow up on that. And that was specifically stated to me by many administrators in the district. And I would also say that we are not alleging that it was just third party, as Mr. Badger said. We allege that the board, the teachers, administrators, and students were involved in this action. So it is not just a third party. It is actually staff members, including a substitute teacher, a teacher on payroll, administrators, and school board members. So it is school culture as a whole. And I want to just reiterate, the comment made to me by a school administrator was they didn't want to keep pursuing this case because it was like a match in a dry, lighting a match in a dry forest.
Is that something that's in the record?
I'm not sure if it is. It was actually stated. It should be in the record. I believe it was in the record.
Forgive me, I apologize.
No, that's okay. I think this comment speaks to the idea that you brought up, sir, Mr. Ashby, about the culture of the school as a whole. The school is very aware of the culture. The administrators made it clear to us on many occasions that they were very concerned to push any further, that it would start a cultural issue in the whole community. So, I mean, the idea that this wasn't a cultural problem that the school was fully aware of is absurd, in my opinion, because it was stated to us by many times by the administrators, their level of concern over this issue and how it fed into the bigger concerns.
Anything else, Mr. Barraza? Have you used about just over 3.5 minutes of your 10?
I don't believe so.
Okay, you can use the rest. Well, actually, since the respondent has used their time, this will be your last opportunity other than answering questions if the commissioners have them to present. So last chance.
No, I think we stated our case pretty good in the investigation, and I just wanted to make those points in response to his response to the previous.
Okay, thanks. Commissioner questions. If any commissioners have questions for Mr. Barraza, raise your hand. Commissioner questions for Mr. Barraza. I see 1, 2. Okay, first Commissioner Whitworth, then Commissioner Ashby.
Could I ask this question first of Barbara, or should I wait and ask it later?
Oh, you can ask.
So Barbara, my question is, should we be considering this particular case as an isolated case, or should we be considering the culture of the school as we consider this case? Because I see it as 2 different things, and I just want to make sure I'm thinking in the right direction.
Well, a hostile environment case looks at the entire educational environment, not necessarily just isolated incidents. Those specific incidents were picked out in the report to talk about. But if they were merely isolated incidents, then we'd be using a different standard entirely. The hostile environment standard is meant to look at the entirety of the circumstances. And while we're talking about the legal standard, I would just point out that the correct one was used in the report.
Thank you, that helps. I don't have anything more.
Yeah, as far as the Doe versus Clenchey, that Superior Court decision was overturned by the law court, granted on different grounds, but the reasoning is no, it's not binding on anyone, because that's not the standard. It's not the standard we've ever used. The standard we use is the usual hostile environment claim. And as to whether or not the action was prompt and effective, that's a defense. So assuming that there's been a hostile environment, a hostile educational environment established, being made by students, teachers, board members, whoever, then the school can avoid liability by showing that even though the environment was hostile, they took prompt and appropriate action to end the harassment. So again, I just wanted to lay out that standard is the standard that the commission has applied both before and after Maine's. It is knowingly broader than the Title IX standard.
Thank you. That's very helpful. Thank you.
Commissioner Whitworth, any questions for Mr. Barasa?
Not just yet, thanks.
Okay, next, Mr. Ashby, and then Mr. David.
Well, and I may want to, I guess I want to address my questions or comments to Barbara first, and then I'm not sure what I have for the complainant. But Barbara, I think I heard you say pretty broadly that the response is the defense. If they respond appropriately, it's the defense, but the environment alone doesn't create a cause of action, right? There still is the obligation that the respondent knew or should have known, right? I mean, we need that obligation first.
I mean, sure. That's
Well,
part of.
For example, I mean, by way of example only, one might argue that the comments on social media are not something that creates a hostile environment for which the respondent is liable. If the respondent had it's a third-party actor and had outside the school, arguably, and the respondent had no knowledge of it at the time that it happened. The analysis has to be the school's response, correct? That has to be what either does or doesn't create a hostile environment.
No, the actions create the hostile environment. The school's response dictates whether or not they're liable. So if you think they didn't know, then it would be inappropriate to hold them liable for that particular action. But again, we're looking at an environment. But I mean, obviously they need to have known about it in order to be held liable for the hostile environment. But that's not about whether or not the act was part of the environment. It's about whether or not there is liability for the school.
If I could just great back and forth, but I'm gonna just for a second see if we can finish questions for Mr. Barasa before we have the commissioners sort of debating the legal points, unless you need to know that to ask questions of Mr. Barasa.
I'm all set. I have no questions for Mr. Barasa.
Okay, Commissioner David, questions for Mr. Barasa?
No, I'm still concerned about the standard. And
yes, I get that all of you are, and I'm not trying to cut that short. I just want to finish with the parties before we turn to the commissioners analyzing the issues.
We could maybe let Bob present too.
Yes, last chance, commissioners, questions for Mr. Barasa. Okay, thank you, Mr. Barasa. And then we turn to the investigator, Mr. Beauchesne. You're muted, Bob.
There we go. Good morning, everyone. Just to briefly, I guess, get to my conclusion in this case, as noted in the final paragraph, the primary issue for me here was that even though the school did respond appropriately to most of the incidents soon after they happened, the end result was nevertheless that complainant was placed in a situation where she was forced to purchase a vehicle and carry a weapon, mace, to school in order to increase her chance for safety in the school setting. So whatever the school had done with regards to each particular incident in the past, it was not corrected in that the harassment indeed continued, as I say, to the point where the only reason why the safety issue was resolved in this case was because the pandemic resulted in complainant being away from school and schooled at home at that point. So again, while each of the minor steps and in some case major steps that the school took, the end result, as I say, was the same, that they were unable to provide an environment in the school setting where complainant was able to access education without simultaneously have to be concerned about whether or not somebody in fact might take action against her, including assaulting her, based upon the threats that were found in the Instagram posting and in the telephone setting. Again, I believe in this case, the school again did take some steps. They sent out a corrective letter after the offensive comments were made at the school board meeting. But again, there was nothing in the record to indicate that the school specifically addressed the student body and told them, look, anybody who is caught harassing or threatening students based upon their sexual orientation is going to be subjected to whatever discipline might be appropriate under the circumstance. So again, whether or not they had an affirmative duty to do it beforehand to ensure that faculty and the students were aware of their position on the matter, it was more reactive versus proactive in this case. I'm ready to answer any questions that you might have.
Thank you, Bob. Any commissioners with questions? I see 1, 2, 3. First, we'll go first, Commissioner Whitworth, then Ashby, then David.
So I'm trying to make the transition from employment to education, and I'm having a little bit of a struggle because that's the world I live in. But my question has to do with what you just said, Bob, reactive versus proactive. So it seems to me that being reactive is taking prompt and remedial action. It seems like being proactive is sometimes something that can't be done unless whoever is the respondent actually knows about it. So could you elaborate a little bit on the reactive versus proactive?
Well, I guess just for a particular circumstance with respect to the offensive comments made at the school board meeting, there had been prior meetings where things had become very heated, debating certain issues, including the use of gender-neutral bathrooms. So in that case, it was my view that the school board could have specifically, before the additional conversation started at the subject meeting, simply warned people beforehand that while they were free to express whatever views they might side with, that there needed to be a level of respect and non-offensiveness, regardless of whatever that political view was. And in this particular case, again, there was a debate about whether or not the school board chair should have shut down the conversation the second it became clear that the speaker was making some offensive comments. Whereas in this case, although the individual was eventually gavelled down, following the meeting, complainant spoke with the chair, who indicated that her hands were somewhat tied because she had to afford the speaker the First Amendment right to essentially say whatever they want. Again, no one would have tolerated had this individual started spouting racist comments at the meeting, whereas in this particular case, there was the claim by the chair that somehow these comments were protected, essentially regardless of how offensive they were. And again, my view was, again, it wasn't that singular event, but also the fact afterwards, again, at a subsequent school board committee meeting, principal disclosed in front of other members of the public a certain aspect of the safety plan that had been discussed between student and her family and the school. So again, in that particular case, it was placing the complainant arguably at even higher risk because now others were aware of what the safety plan might have entailed. So again, that one wasn't a failure to take action beforehand or response. It was simply a question where it was certainly deemed inappropriate that any aspect or even acknowledging that a safety plan existed was wrongful for the principal to have that discussion with complainant in a public setting and apparently in front of individuals with whom complainant had had prior issues about the particular bathroom issue.
Thank
All
you.
set, Deb?
Yep, thanks.
Okay, Commissioner Ashby. Drunk with power, I've taken over for Amy.
So Bob, I have concerns about your conclusory paragraph that you referenced when you first started speaking in defense of the investigation. It's not the standard is not whether or not this individual felt that the steps taken by the school were adequate. It's a reasonable person standard, correct? I mean, I think you make a fairly conclusory statement that even though, I'm going to paraphrase, but you say, even though the school did respond promptly and appropriately, it obviously there still was a hostile environment because this particular complainant didn't feel safe at the school and had to take her own vehicle and that sort of thing. That's not really the standard though, is it?
I'll defer to Commission Counsel on that.
Okay, so the hostile environment standard requires that the environment be both objectively and subjectively offensive. And in the school context, that's objectively and subjectively offensive to someone of the same age and
Right.
maturity level of the student.
Sure. Thank you for clarifying that. This is unrelated, but on page 5, you reference, and I know that the complainant in his comments a moment ago just referenced it as well. On page 5, you mentioned for the first time, sort of deep in the paragraph 5A, this use of this offensive slur. And I can read between the lines. I infer from your report that the principal did not actually use a slur to call the complainant that word. But can you help us understand what the context was for that? Because that kind of jumped out at me late in the reading of the report. I think it'd be an easy case if we understood that the principal called the complainant that, but my guess is that's not what happened. Can you help us understand what did happen?
Certainly, my understanding was, although the principal, I believe, denied, in fact, making any type of offensive comment during the meeting with complainant, the record appeared to suggest that if it was used, it wasn't directed specifically at complainant. He was not calling her that particular name. It was a question where whether or not it was inappropriate for the word to be used in the conversation. Again, sliding to a racial type of parallel, were someone to use an offensive racial term, even in the context of a conversation where they were trying to address the issue, doesn't necessarily make it appropriate. So I believe, again, it was just a suggestion, again, that the overall environment with respect to the staff, what hadn't perhaps been properly trained as far as how to discuss these issues without having to refer to offensive terms in the context of that conversation.
Yeah, I think I hear you just now defending your suggestion that it was relevant, but my question is, can you tell us what actually happened? What context was the word used in? And I think the principal did acknowledge, right, that he might have used it. So he didn't deny it outright, he or she didn't deny it outright, just acknowledge that he might have.
Right. My understanding was the meeting had taken place. I'm not certain which particular incident led to this, but it's my understanding that there was a conversation between principal and the minor complainant with respect to a recent incident. Apparently during the course of that conversation, the principal had used that word, I believe, to illustrate a particular point. So the question is whether or not the use of the term should be excused or forgiven simply because it was a meeting designed to address a situation, or whether or not the principal should have been aware beforehand that any use or context of that term might be offensive, especially to complain, and whether or not it could have been addressed in a different manner.
Okay, I have no further questions. Thanks, Bob.
Muted myself again. Commissioner David, any questions for the investigator?
Yes. Good morning, Rob. Is it simplistic of me to think that what you're saying is that even though some of the responses are appropriate and prompt, the respondent is still responsible for the hostile environment. And what they did was inadequate, and they didn't cure the environment. I mean, the respondent here is the institution, and it has the responsibility to cure the hostile environment. Is that too simplistic? And maybe that's for Barbara also.
I'm not quite certain what the question was.
Well, then I'll take it. I do not think you were being too simplistic. I think that that was a nice, clear summary of what the report is getting at.
Well, thank you.
Look at me.
Any other commissioner questions for the investigator? Yes, Mr. Ashby.
Maybe it's for Barbara or related to that last comment. It's an impossible standard, I think, that you impose upon a respondent if they have to cure all instances where kids or people on social media or even parents at school board meetings make comments. It's how they respond and then how objectively the response is deemed to be adequate or not adequate. It's not that they, I promise you that in this school district, there's going to be someday down the road, someone makes a slur. And it can't be that the respondent has an obligation to have cured all potential future incidents in which someone would be admittedly appropriately offended.
Yeah, that's not the standard that anyone is trying to apply, and that is certainly not the legal standard. We're not saying that students are insulated from their fellow students being mean, because high school would be a whole different place then. What we're saying is that what's prompt and effective, well, what I'm saying anyway, what's prompt or effective for the first incident is not necessarily prompt and effective when it's 2 years later and these things are still happening. So again, the standard is to look at whether or not the environment was so hostile that it prevented the student from accessing their right to an education. And I mean, the legal standard is what it is. Whether or not you think this case meets that standard is a whole different issue. And I get that you're saying that you don't think it does.
Well, I'm not sure where I land on that. But it's helpful to talk it through. I did take issue with what I thought was a too simplistic assessment of the legal standard, but your comments are very helpful, Barbara. I really appreciate it.
Any other questions for the investigator? Seeing none. Thank you, Bob. So commissioners, you can continue the discussion, which is a very healthy one. There is one proposed finding here, so we would be looking for a motion.
Sorry, everything was frozen until right then for me. So Jeff, if you asked anything or called me dumb, then I don't know about it.
He called you really dumb.
Everybody.
And it's a good thing you missed it.
Phew.
I think I said you were very helpful, I think was the last thing I said.
I missed the whole thing. Thanks.
I'll move that there are no reasonable grounds to believe that the respondent discriminated against the complainant on the basis of sexual orientation, and that the complaint should be dismissed in accordance with the act.
Second.
So it's been moved and seconded to find that there are no reasonable grounds to believe that unlawful discrimination occurred against Mr. Barasa individually and on behalf of minor child on the basis of sexual orientation. It's been seconded. Is there any discussion?
Well, go ahead.
Commissioner David.
Yeah, as I indicated in my question, and responding to you, Jeff, I don't think I'm not thinking that the school board as an institution has an obligation, or that it would be possible to prevent any untoward racist or homophobic or discriminatory behavior by individuals. But it's not sufficient to me to say well, they respond to this one incident and to that one incident, and that it still goes on and that it continues to go on. I think they're responsible for not changing that environment, and I can think of a million things they could do to make me a lot more sympathetic that they tried.
Well, I mean, the school has a civil rights team that shows a proactive desire to do the right thing. They're holding school board meetings about this. They're apologizing when school board meetings go off the rails, but they don't silence the citizens of that town when they do come to the meetings. The findings of the investigator are that I think in every case, respondent did respond promptly and appropriately. The instance of reported harassment. And I don't think that the standard is that because this complainant wasn't satisfied with the response, it must mean that the hostile environment exists for which the respondent is liable. I quite frankly don't see how the school, at least from a legal point of view, could have done things differently. Well, they could have done things differently. I don't think they could have done things in such a way that they would have been less or more legally liable.
Commissioner O'Brien?
Yeah, Commissioner David, I'm curious as to, you said there are several things, many things they could have done. What do you see that they could have done more?
I'm going to encourage, and it feels weird. I don't want to overstep, but I'm going to encourage commissioners to stick to the facts that are on the record, not imagine things that might exist. So, and I apologize, I'm not trying to shut down discussion. I'm just trying to keep it to the record. Is there any other discussion from commissioners of the pending motion before I call for a vote? Seeing none. So the motion is to find no reasonable grounds to believe that there's unlawful discrimination based on sexual orientation. If you say yes, you agree with that. Commissioner Whitworth?
Yes.
Commissioner, okay, thank you. Commissioner Ashby?
Yes.
Commissioner David?
No.
Commissioner Duson?
No.
Commissioner O'Brien?
Yes.
So by a vote of 3-2, the motion passes to find no reasonable grounds to believe that unlawful discrimination occurred. And the commission will send the parties and council a letter reflecting that. Hold on one second. So that hearing is completed and we will move on to the next.
Our next one is E20-0178, Allison Tunick, the Maine Maritime Academy. There's a no reasonable grounds recommendation. Is there anybody here for the complainant? Excuse me.
Yes, Lisa Butler for complainant Allison Tunick.
Good morning, Ms. Butler. You have 10 minutes.
Good morning. Okay, I'd like to introduce my client first. She is here on the Zoom. She is identified as Allison Tunick. The investigator's report relies on an incorrect interpretation of the facts, which skewed its recommendation. We also submit that the applicable legal standard of but-for causation was not properly applied in this case. And if it were applied properly, the conclusion would be that there are reasonable grounds to believe that Maine Maritime Academy, which is the respondent here, retaliated against Ms. Tunick because she made a complaint about her pay that she was legally entitled to. The factual error that we have pointed out several times is that At the outset of Ms. Tunick's employment with Maine Maritime Academy, the Academy provided her with an offer letter that specified that she was to be paid $50 an hour, and that the coordinator of continuing education would contact her and inform her of what they were asking her to do. That is a critical fact legally, because that letter is binding on Maine Maritime Academy. So the report incorrectly took the position that the payment arrangement specified in the offer letter was irrelevant, and that there was somehow an agreement to pay a stipend for a manual that the coordinator asked Ms. Tunick to work on. That statement of a stipend or assertion there was an agreement for a stipend is not supported by the record. So moving from the fact that Ms. Tunick was supposed to be paid by the hour for her work, the question is whether, when Ms. Tunick ran into time overruns in work on this manual and the coordinator ended up leaving, whether Maine Maritime was obligated to pay her for the work she had done. There did come a point in the relationship where the director of continuing education told Ms. Tunick, don't bother to finish the manual for us. That's why Maine Maritime did not end up with a manual, was the director for continuing education decided that he was going to assign that project to another person who does curriculum development. At that point, Ms. Tunick decided that she did not want to continue to work for Maine Maritime Academy in that position and did not continue to do any further work. And she asked for her pay for the work she had already done. The investigator made a credibility determination, which is not supported by the record, in saying that the Maine Maritime believed Ms. Tunick was being manipulative and dishonest. There's nothing in the record that establishes that. The investigator didn't even interview the witnesses. And in fact, as a matter of law, Ms. Tunick was legally entitled to be paid by the hour for the work she had done on the manual. Those are important facts. What happened thereafter is that when Ms. Tunick, who happened to have been the valedictorian for Maine Maritime Academy, when she did graduate from there, when she reapplied for a position in 2020 as an assistant professor, she'd worked in academic teaching positions before, she basically ran into silence from the HR office, which was handling her application. Eventually, she found out that she was not going to be interviewed for the assistant professor position. And she then started inquiring, and we ended up filing a charge of discrimination with the Maine Human Rights Commission. At the Maine Human Rights Commission, we found that Maine Maritime had written in Ms. Tunick's personnel file, not for rehire. That's blacklisting. The issue that led to Ms. Tunick's blacklisting was that she had asked for her pay, then demanded her pay for the work on the manual. That's statutorily protected conduct. And this is where the investigator made a fundamental error in saying that the commission should find that it wasn't the fact that Ms. Tunick complained about her pay, but rather the manner in which she did it, which motivated Maine Maritime Academy. You can't divorce the fact that a complainant engaged in protected activity from the manner in which it was done. Under the proper application of the but-for standard, which is what we have here, it's undisputed that the reason Maine Maritime designated Ms. Tunick permanently as not for rehire was because she had complained about her pay that she was legally entitled to. So that is the fundamental error in the investigator's report's recommendation to you. And we submit that the commission should not accept that recommendation. That recommendation is based on other factual errors that I've specified in our submission of disagreement. I'm not going to recite them all here, but I'd be happy to answer questions. The question before the commission is whether there is whether there's a basis to find reasonable grounds. And we do object that the investigator made this recommendation without even conducting an issues and resolution conference. Witnesses to this action have provided no information in person to the commission. It could have been done very easily by a Zoom, and we submit it is inappropriate for the investigator to make a credibility determination based on such an incomplete record. The question is there enough admissible evidence that there's at least an even chance that plaintiff will be able to prove in court by a preponderance of the evidence that discrimination occurred? And we submit, based on the facts in the record here, there is more than an even chance that Ms. Tunick will be able to prove that she was barred from reemployment permanently by Maine Maritime Academy because she complained about pay that she was legally entitled to. So that is the essence of our case. I would be happy to answer more any questions that the commissioners have. And I ask that you find that there are reasonable grounds to believe that Ms. Tunick was barred from reemployment by Maine Maritime Academy in violation of the Maine Whistleblowers Protection Act. Thank you. I'll reserve the remainder of my time.
Okay, you have about 15 seconds left when we get back to you. Any questions for Ms. Butler from commissioners? Raise your hand if you have any questions for Ms. Butler. Commissioner David.
Attorney Butler, as I understood it, am I understanding correctly that you're saying that she was entitled to be paid on an hourly basis for the work that she did?
Yes, and that's specified in the offer letter that I attached to as Exhibit 1 to our submission of disagreement.
Oh, you're muted, Commissioner David, you're muted. Still muted. There you go.
Yeah. I'm reading that offer letter, and that's what I want to ask you about. June 25th to her says offer the temporary part-time non-benefits eligible position of instructor for the following course, and describes the course. Your entire presentation has not mentioned at all the sum of $1,600 or the writing of the manual, which is not in this offer of employment. And it seems clear to me that they are distinct, and you're merging them together. How do you respond to that argument?
I believe that this offer states that in the conclusion to the first paragraph says the duties and responsibilities of the position are outlined in the position description, but may be modified as our objectives and mission change.
And you're saying that it's modified by changing a course description as to the subject matter of the course, which is what I assume is described, to say write a manual for that course? That I find a stretch.
The coordinator for continuing ed was the person who worked with Ms. Tunick and asked that the manual be written, and the director of continuing education approved that. So that is the there is no dispute that the director of ed approved the assignment to work on a manual. And then the question thereafter becomes, legally, what is the compensation that Ms. Tunick was entitled to for work on that assignment? And so that is our position, is that the offer letter set an hourly rate of pay, and that there's nothing unreasonable in Ms. Tunick's request to be paid for the work that she actually did. And as is spelled out in the charge, part of the issue arose because the coordinator of continuing education left, and the director of continuing education took shifting positions on what he wanted Ms. Tunick to do, which ended up in a breakdown where he said, no, forget it. No manual. You're not gonna, I'll give the manual to someone else. You have no first choice on teaching the fast rescue boat course. And no, we're not sending you to Louisiana for a training so you can work on the manual. So that's where things fell apart. But the legal entitlement to pay is established in this letter. And there's nothing that said that $1,600 was the total amount that she was to be paid for work on the manual. The continuing ed director approved $3,200 in about June. So I hope I've answered your question.
Mr. David, all set? Okay. Any other questions for Attorney Butler from commissioners? Seeing none, we will turn to respondent. I believe that's Ms. Forster.
Good morning. My name is Assistant Attorney General Sarah Forster, and as Ms. Sneerson and Ms. Hirsch probably know, it's a shock that I wasn't involved in the prior case you heard, since my expertise is in education law and I represent the Department of Education. But today I'm here representing Maine Maritime Academy, and we support the findings of the investigator. I would bring to your attention first that, as Commissioner David pointed out, there is a written agreement, a one-sentence email. It's all yours, $1,600 for the completion of the handbook. That is not part of Ms. Tunick's then existing instructor contract, and it is not an hourly rate. Ms. Tunick acknowledges this, again, in the record. This is at Exhibit 6, page 9, when she's asking for additional money, $1,600 more. She says, I'm not asking to be compensated for the time that I've already worked because I'd agreed to $1,600, but I want $1,600 more to further improve the manual. So there's no question that both the coordinator, who then leaves Maine Maritime Academy, and Ms. Tunick see this as a work for hire for a manual, a handbook. However, The coordinator knows that she doesn't have the authority to do this because the record shows, again at Exhibit 6, both the coordinator and Ms. Tunick meeting with the director about the request for $1,600 more to be sent to a training in Louisiana for the right of first refusal and a list of other things. So what does the director do now that he is aware that there's a one-sentence email agreement between his subordinates, the coordinator and an instructor, for a handbook? He hears them out, and the record shows that he says to Ms. Tunick, and I've looked into it, there's no funding for Louisiana, and it makes no sense to me that we would give you the right of first refusal because you're a pool instructor. The whole point of having a pool instructor is to have a number of people able to teach the course. He does not authorize the $1,600 extra. In fact, he realizes that his coordinator has gone sort of off to the side and even entering into the agreement. Ms. Tunick doesn't continue to work on the manual. And in fact, again, she describes her own manual as, quote, a manual, sort of. Finally, again, now we're moving forward into June, the director tries to bring an end to this by saying to Ms. Tunick, in an email, again in Exhibit 6, if you agree to work with the development instructor, I know we're not supposed to use names, to complete the manual, you can have the $3,200. And at that point, Ms. Tunick says, and again, you can read it in Exhibit 6, if you want to give the manual to someone else, that's fine, but I'm not working with him. I was promised $3,200. I want my money. So it's not, as counsel said, that the manual was taken from her and assigned to someone else. She was given the terms by which she could have gotten all $3,200 to complete the manual, and she chose not to. She also informed them, I'll take $1,600, which is half of what I've owed, and quote, I have no further interest in working with continuing ed. This is all in Exhibit 6. So she's done. She's left the university, the academy, I'm sorry. The academy has no manual. And they make the decision that because she's left the academy, and so none of these other things are on the table, this has already taken up time and bandwidth. She sent an entire chain of emails to the president of the academy, throwing all of the continuing ed people under the bus as no one knows what they're doing over there. They decide to pay her the $3,200, even though they have no manual, and designate her not for rehire because obviously it was not a successful employment relationship. The investigator correctly concluded that based on that chain of events and escalating behavior by the complainant, and the fact that a manual was never delivered for $1,600, for $3,200 was never delivered, that was the cause of the decision that she was not for rehire. And so based on the but-for standard that the investigator correctly applied, she concluded that there were no reasonable grounds to believe that a reviewing court would find, using the civil standard, that her decision or the decision of the academy not to rehire her was because at the 11th hour, she filed a letter claiming a wage and hour violation, which of course is inconsistent with her own statements that she was to be paid an amount for a piece of work. If the commissioners have any questions, I'm happy to do my best to answer them. Thank you.
Thank you. Just a second. Any commissioner questions for Ms. Forster? I see Mr. Ashby. Okay, just Mr. Ashby. Go ahead.
So your analysis, your focus on the facts and the last statement you just made suggests that the complainant doesn't prevail here because she wouldn't even show an even chance of prevailing in court on her wage claim. Is that too simplistic or is that accurate?
No, Commissioner Ashby, what I'm saying is she doesn't stand a more than 50% chance of prevailing on her retaliation claim. In other words, that it was but for causation.
Well,
I would
helpful.
say.
Oh, go ahead, I'm sorry.
I'm so sorry. I would say though, however, the only area in which we disagree with the complaint investigator is we actually think, for what it's worth, that letter claiming a wage and hour violation is not itself even protected activity. And we can explain why that is and why we think the law court has sealed that off. But in fact, it's not necessary for the disposition of this matter, because as you so accurately set it up, the question is, does she have a better than 50-50 chance in court to prevail that the basis for flagging her not for rehire was her protected activity, as opposed to a course of escalating conduct that suggested she was not a good employee for Maine Maritime.
Well, that's really a helpful analysis, because my next question was going to be, is every wage claim in which the claimant does show a better than 50% chance of prevailing at a prima facie level, is every wage claim then a WPA claim under the Human Rights Act?
Boy, here's where I say, this is not my specialty. And this maybe Ms. Archer Hirsch has a better idea about what the law is with respect to that. My point here today is that the investigator did an excellent job getting to the meat of what this problem was. An agreement, $1,600 for a manual. There is no manual. There's a whole bunch of bad feelings and escalating conduct among the parties. And they decide, we'll pay her the $3,200, but we're not going to be in a future employment relationship.
All right, thank you.
Thank you.
Any other questions from commissioners, for Ms. Forster? Nothing, I don't see anything else from commissioners. Before I bump back to Ms. Butler, I would just remind commissioners the legal standard is at least an even chance, not better than an even chance. So back to Ms. Butler, which you have 15 seconds, Ms. Butler. You're muted.
Can you hear me now?
Yep.
Okay, there are many facts that have been presented in this case. We disagree with the recitation of facts by respondent's attorney. The agreement about payment
Ms.
for
Butler,
the manual.
Ms. Butler, I'm sorry. That's the 15 seconds.
All right.
Commissioners, any follow-up questions for Ms. Butler? Any questions from commissioners? Seeing none. Ms. Forster, you have about 4.5 minutes left if you want to use them. You don't have to, but you can.
No, thank you, Ms. Sneerson.
Okay. Okay, then we will turn to the investigator. I believe that is Ms. O'Reilly.
Good morning, commissioners. I hope you can hear me. I'm having a little bit of a delay on my screen. So just let me know if you need me to repeat myself. I won't add a great deal to what's been presented by the parties. I think council has pretty well outlined their arguments in this case. I'll just point out again, respondent's attorney was, and Commissioner Ashby's question was correct. There's two sort of distinct arguments that went on in this case. Both was the actual dispute over the wages itself, and the second was the argument over whether or not complainant had been designated not for rehire due to her report of illegal conduct. And the only thing I was analyzing in my analysis was whether or not the retaliation had occurred. I'm also happy to, as you know, in many of our cases, some of them we have conferences, some of them we don't. I just wanted to briefly address that point brought up by Ms. Butler. I won't go into detail, but if you have any questions about why I chose not to do interviews in this case, I'm happy to answer them.
Thank you, Jane. Any commissioner questions for the investigator? Seeing none. Okay, thank you, Jane. Okay, so we've heard from the parties and the investigator. At this point, we would be looking for a motion.
I'll move that there are no reasonable grounds to believe that Maine Maritime retaliated against the complainant for whistleblower protected activity.
Second.
So it's been moved and seconded. Is there any discussion?
Just speaking for the motion, wage disputes are not unlawful discrimination or retaliation.
Any other discussion? Seeing none. The motion is to find no reasonable grounds to believe that Maine Maritime retaliated against Ms. Tunick for engaging in Whistleblower Protection Act protected activity. If you vote yes, you are in agreement with that motion. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Dusan,
Yes.
Commissioner O'Brien.
Yes.
So the vote is to find no reasonable grounds to believe unlawful discrimination occurred, and the hearing on this case is completed. We will send the parties and counsel a letter regarding the finding. Thank you. Our next case, I believe Commissioner Ashby is recused from.
Sorry, I was muted. Our next case is PA 20-0289 ABCD, Michael Stigl and Chandler Dixon v. County Remax, Jane Towle, Lee Smith, and LSS Holdings
And we're
LLC.
going to get up about James Hall quickly.
Okay, we can hear you, but we don't want to hear you yet.
This is a no reasonable grounds recommendation. Is there anybody here for the claimant?
Now we're ready to hear from you, Mr. Stigl and Mr. Dixon.
Yep. Hello. Hello. Okay. So you guys are ready to get into the meat and potatoes on this right now?
You have 10 minutes.
Yeah. And one question we have, if we don't use those 10 minutes, can we use that, the whatever's left for the closing argument?
Nope.
Oh, you can't. Okay. Nope. That's what I. Okay. All right. So I can go?
Yep.
Okay. I'd like to first of all state my name for the record. My name is Michael Stigl. I am a resident of Mars Hill, Maine. I want to thank the commission for this opportunity to speak before them. And I'm going to go right into this claim of discrimination in regards to a commercial rental property. The defendant or respondent in this case that owns the property, LSS Holdings, my recommendation based on what the investigator has reported in his reports is for the commission to reverse the preliminary investigation report by the investigator, because the investigator did not do a complete job investigating this case. I'm willing to point that out. If you can look at the complaint, and if you look at the first page, and we can call that exhibit 1, under factual background, the investigator says that this occurred in mid-June 2019. This did not occur in mid-June 2019. This occurred mid-June 2020. So that tells me that, you know, it was a haphazard job in getting all of the details. But furthermore, there's a pretext issue in this particular case. The respondent states that the reason for not allowing Mr. Dixon and Mr. Stigl to see the property after he doubled the rent, and it was because there was an issue with communication with Mr. Stigl. I would challenge anyone on the board to say that when you go to purchase a home or to rent an apartment or to rent a commercial space, that you're going to be professional in your dealings with whoever you're dealing with, because you're trying to get access to something that they have. Doing the interview on the phone, because we did speak with the respondent LSS Holdings owner on the phone, and he questioned us. He questioned who we were, you know, and we talked about the business that we currently own in Mars Hill. He also told us what he wanted to know. What were we planning on doing with that space? And we shared with him that we were planning on doing a medical marijuana dispensary. He said you may want to check with the town because of the movie theater, the proximity of the movie theater. We had a date and time to look at that property. And then the next day, the rent was doubled. In the investigator, in his report, I don't see where the investigator asked for canceled rent checks for the 399 Main Street. And I don't see where he asked for canceled rent checks for the Fort Fairfield property, because there could have been a comparison made that would give everybody, it would remove the shadow of discrimination and discriminatory practices, which I believe that we're protected by civil rights laws. And we want to move the needle and not have these occurrences of something is advertised for rent, you make a professional phone call to try to rent it, and then you are pre-screened by all of these questions. You give all of the answers. You're told that you have an appointment to see the property, and then the next day the rent's doubled, and you are blocked from seeing it, and put in a situation where the communication breaks down. So then you're blamed for it. So again, I'm going to ask the commission to 100% reverse the decision by the investigator, to really look at the facts in this case. And again, we do want to say for the record, Jane Towell, oops, excuse me, I'm sorry about that.
That's okay to do because she's a party.
Okay, sorry. Okay, thank you. Jane Towell, County Remax, unfortunately was she was named in the suit. County Remax was named in the suit or in this claim, but this could have been taken care of with effective communication from County Remax. All they had to say from the beginning is that although he advertised with their number, they had nothing to do with renting this commercial space, and that they did not want to be involved in it on any level. But Mrs. Towell, being a court mediator, decided to involve herself and try to mediate this problem that we had, and it failed. And I would say, if the allegations were false, why did she even open up anything to mediation? But we're not here today because of Mrs. Towell or County Remax. We are here because LSS Holdings, a Aroostook County company, displayed discriminatory practices in commercial renting. I'm gonna give the rest of the time to Mr. Dixon.
I would just like to again thank the commission for this time. I'd like to simply bring some clarity again to the facts. Lee Smith, or LSS Holdings, the defendant, he did not rent to us based on our race. We know this to be true because we told him who we were. He probed us. He asked us, who are you? Why do you want to rent this property? We told him we were the owners of Timberwolves Barbecue, that Timberwolves Barbecue is one of the only African-American owned.
I'm sorry, could you not use the name of your company because that's not a party here?
Yeah.
Thank you.
So we told them the name of our company and that our company was one of the only African-American owned companies in Aroostook County and the only African-American owned company in Mars Hill. And then there's a pretext with the rent. He had quoted us $775 a month for the property in Presque Isle. Then the next morning, after he failed to show up to our meeting at the property, he said that he had confused the Presque Isle property with the Fort Fairfield property, and the property in Presque Isle was $1,500 a month, which is double. That is a lie. to say that he confused the properties because we told him that the property was in Presque Isle. He even told us that if we were to do a medical marijuana storefront in Presque Isle, that we would have to check the distance between the storefront property and the movie theater, which is located in Presque Isle. And there's no movie theater located in Fort Fairfield. So it's obvious that he was lying about the rent in order to discourage us from showing the property. And then even once he doubled the rent, we said that clearly that we would still like to see the property and we'd still like to rent the property. At that time, he simply blocked communication, all communication with us, and left us no other option than to take legal action. And in summary, we would just like to ask the commission to reverse the decision of the investigator. Again, because the investigator quotes the defendant's spoken word as facts, but does not take into account our spoken word as facts. And the investigator clearly rushed the report because all of this took place in the year of 2020, and he quotes it as being in mid-June of 2019.
And I would just like to say in closing, again, we just want to thank you for your time. Thank you for this opportunity, and thank you for the process. Thank you.
And then I would just like to invite the commission to please ask us any and all questions that you have so that we can respond with clarity.
Okay, thank you. Any commissioner questions for Mr. Stigall and Mr. Dixon? If so, raise your hand. Let me see. I do not see any questions from the commissioners. So at this time, I'm going to mute you. You have about 30 seconds left after we hear from the respondent.
Okay.
Mr. Swanson.
Good morning. My name is Adam Swanson. I represent the respondents, Remax County, Jane Toll, Lee Smith, and LSS Holdings. Lee Smith is the sole managing member of LSS Holdings. LSS Holdings is a real estate holding company with multiple properties throughout Aroostook County. Mr. Smith rents more than 100 units and owns office space in Fort Fairfield and in Presque Isle and in other parts of the county as well. Mr. Smith also works for Remax County as a real estate broker. The transaction in question here, Mr. Smith was not acting in his capacity as a real estate broker for Remax County. He was acting as the owner of LSS Holdings. Mr. Smith was first asked about a Main Street property for rent and did quote Mr. Stigall or his associate, Mr. Dixon, the rate of $775. Later, when he realized more about the property in question and the specific property that Mr. Stigall was looking to rent, this was in the course of having to reschedule their first appointment, Mr. Smith realized that they were referring to the Main Street property in Presque Isle and not in Fort Fairfield. The prior tenant of the office space in Presque Isle was renting that space for $1,500 per month, and it's a newly renovated office space. When Mr. Smith clarified and acknowledged that he made a mistake, he was met with disregard by Mr. Stigall. This is by text messages, which were included as an exhibit in our response. Some of those messages stated, "How come the price changed and now you want to cancel? What do you have against minorities?" And making statements such as, "This will not end well for you." Mr. Smith had never seen Mr. Dixon nor Mr. Stigall. He did not know what their race was. He testified to the investigator that even at the time that the investigator conducted the investigation, he still had not actually seen Mr. Stigall and not confirmed his race, nor Mr. Dixon's. Now, when Mr. Mr. Stigl continued to message Mr. Smith in such a regard. He then indicated to Mr. Stigl that, this is not going to work and I'm not going to rent you the property. He decided not to rent the property to Mr. Stigl because he knew it was not going to be a good relationship moving forward based on the assertions and allegations that were being made following his mistake. Unhappy with this, Mr. Stigl then went to Jane Toll, who's the owner of Remax County. Again, that's where Mr. Smith is employed. He spoke to Jane Toll. This was just probably about a day after he had spoken to Mr. Smith, complaining that Mr. Smith had discriminated against him by not renting him the space on Main Street. Ms. Toll wanted to try to help the parties reach a resolution. She serves as a mediator and thought that she may be able to help. When things did not, when Mr. Stigl was not satisfied, he told Ms. Toll that he was going to contact the corporate office and post with social media that she is a racist and cause harm to her business. Mr. Smith made a mistake in quoting the rent. He's got multiple properties, and he believed that they were referring to the Fort Fairfield property when he first quoted them the $775. As a result of Mr. Stigl's text messages and threats to Remax County, a cease and desist notice was sent to Mr. Stigl, and the sheriff that went to serve it said that he got it and tore it up, ripped it up right there, didn't even read it. This was a mistake made by Mr. Smith with allegations of racism immediately following. We'd ask that the commission agree with the findings made by the investigator that there are no reasonable grounds to believe that Lee Smith, Jane Toll, County Remax, or LSS Holdings discriminated against Michael Stigl and or Chandler Dixon, and that there are no reasonable grounds to believe that they retaliated against him. We ask that the complaint be dismissed. I'll reserve my time for further argument. Thank you.
Thank you, Mr. Swanson. Commissioner, questions for respondents? If so, raise your hand and I will get to you. I do not. Yeah, Mr. David?
Attorney Swanson, how does the mistake get made? Are there two rentals available, one in Fort Fairfield and one in Presque Isle? Are they advertised? Yes. Or it's a little hard to believe that somebody calls and says, I want to rent one property and doesn't say what town it's in. How does that happen?
According to, I believe what was found in the investigation and what was asserted in our response was that the initial request was to rent a Main Street property. It was unclear as to whether that was by text message or a telephone call. I don't believe that it was until later when Mr. Smith needed to reschedule that it was determined that they were referring to the Presque Isle property. But yes, Mr. Smith does own properties. There's multiple retail spaces in Fort Fairfield at a business on Main Street. It's a 2-story business. And it had multiple vacancies, as well as a property in Presque Isle, also on Main Street, with one vacancy in that commercial space. Whether they were advertised at the time, I'm unsure.
So that the vacancy in Presque Isle, there was a vacancy and its rent was $1,500.
That's correct.
And it's on Main Street.
That is correct.
Any other commissioner questions for Mr. Swanson? Commissioner Doosan?
Yeah, I just want to be sure I understand. Thank you, Mr. Swanson. There was a appointment to view the property that your client was not available for. Is that what I understood?
There was, yes, I believe that there was an initial appointment to view the property. It was at that time when he went to reschedule because he was unavailable. That was when he realized that this was the Presque Isle property, not the Fort Fairfield property. He did attempt to still reschedule with Mr. Stigall to view the Presque Isle property, but Mr. Stigall continued to send these messages to the point where Mr. Smith later declined.
So unless I misheard, and maybe it's a question for the investigator, the missed appointment. I thought I heard one of the parties, either you or Mr. Stigall, mention that the appointment was made and that the respondent did not appear for that appointment. And it was after that that the respondent sought to reschedule. Am I understanding that correctly?
Yes, that is correct.
Nope. Mr. Dixon, it's not your turn yet. Nope.
Oh, asking me. Okay.
We'll get back to you. Still Mr. Swanson.
Mr. Swanson, yeah.
My understanding was that it was Mr. Smith that contacted Mr. Stigall first to reschedule. He indicated to Mr. Stigall that he had to reschedule it. He was not going to be available for the initial appointment that they had scheduled.
And at that time, he understood the appointment to be in Fairfield or in Presque Isle.
I don't know that he knew where the appointment was to be. I think it was going to be a Zoom appointment, not in person.
I see. To view the property. Okay, thank you.
Any other commissioner questions for Mr. Swanson at this time? Seeing none. Mr. Dixon, you and Mr. Stigall collectively have about 30 seconds left for anything that you want to present.
Okay, again, it was a clear lie that he would have confused the Fort Fairfield property with the Presque Isle property, because again, we stated clearly that it was the Presque Isle property next to Dwight's Barbershop in Presque Isle, and that we were looking to do medical marijuana storefront, which he had no problem with. He said, all we have to do is check with the city of Presque Isle to confirm that it is not too close to a school or not too close to the movie theater. And there's no movie theater in Fort Fairfield. Lee Smith.
That's actually your time.
Okay, that's perfect.
Commissioner questions for Mr. Stigall and Mr. Dixon at this time? Seeing none. So at this point, we're done hearing from the parties, and now we'll turn. Alex Brindley is presenting a report of an investigation done by Milo Gitchos.
Let me unmute myself first before I present. Good morning, everyone. My name is Alex Brindley. Like Amy stated, I was not the original investigator on this case, but I have reviewed the case in full detail. So I will be able to answer any questions. But first, there was a question about this meeting that took place. Now, I don't have there's no evidence about any phone call setting up the meeting. However, there is a text message from the respondent, Michael, stating that our appointment was not for 10, it was at 2, and it was via Zoom. So I think that might answer that question. But if it doesn't, let me know. And I'm also open to any other questions you may have.
Thank you, Alex. Any commissioner questions for Ms. Brindley? Yes, Commissioner Duson.
Yes, I didn't see anything in the record, but I wondered, in your review of the case, is there any indication of what the rental at the Main Street Presque Isle property was in the time frame that the parties' dispute arose?
Let me just double check the record. I didn't think there was anything explicitly requested about sorry, I'm trying to read and talk at the same time. I don't think there was anything specifically requested about the rent in Fairfield versus Presque Isle. So I unfortunately don't have the answer to that question.
far as you can see, there's neither confirmation of what the rent in Fort Fairfield was, nor what the rent in Presque Isle was.
Correct.
Okay, thank you.
Any other questions from commissioners for the investigator? Mr. David?
Yeah, Alex, you just said there was nothing in the record as to what the rent was for either property?
So like no actual records, the only thing we have is the respondent's word. If I understand the record completely, is that we only have what the respondent stated was in Presque. The previous renter rented it for $1,500, and that's what they're renting it at. And then in Fairfield, it was $775, I believe. But I don't think there's any like physical past records of how much the rent was in either place.
Okay.
Any other questions from commissioners for the investigator? Seeing none, Commissioner Doosan, you look like you're thinking about it. Do you have another question? Nope.
Well, it's just because I think I understand the record, but because this really turns on the assertions between the oral conversation between the parties, I just want to make sure I didn't miss something. Is there anything in the record that indicates that there is indeed a movie theater near the property in Presque Isle and no movie theater in Fort Fairfield?
That is a good question. Let me just review the record real fast, because I remember reading about a movie theater in Presque Isle, but it might have been, apologies, that one of the past buildings was a movie theater, but that might be more of a question for the respondent attorney. Let me see.
For what it's worth, I'm the other person who's read the record in its entirety. So for what it's worth, I do not recall that information being in the record.
Yeah, I'm fairly sure the investigator did not obtain that information. Any other commissioner questions for the investigator? Commissioner Doosan? You're muted. Okay, there you go.
The nature of the interactions between the parties, which are the nature of the interactions from complainant, which are described by respondent as threats. Is there information in the record that characterizes those interactions as anything other than discussion of their feeling that they were being discriminated against? In other words, I didn't see anything in the record that alleged physical threats or threats beyond the complainants pursuing their concern that they were being discriminated against.
Well, I believe the respondent stated previously that, or it might be in the record, I don't exactly remember where, I apologize, that it was Miss Towell. They said that they would go to her place of business and take photos of her car. But I believe in the text message exchange, it really mostly relies on the fact that they feel like they're being discriminated against and that would be filing a complaint with the Maine Human Rights Commission.
Any additional questions from commissioners for the investigator? Seeing none. Thank you, Alex.
Thank you.
So at this point, we've heard from the parties and from the investigator presenting the report. And we would be looking for a motion. Oh, there are two proposed findings.
Ms. Sneerson is frozen on my screen. I don't know if others are experiencing. Oh, now she started moving.
No, I'm just not moving.
Okay.
Yes, at this point, we need a motion or motions. There are 2 proposed findings. Commissioner Dusan,
I will make a motion that there are reasonable grounds to believe that Lee Smith, Jane Towle, County Remax, and/or LSS Holdings LLC discriminated against Michael Stigler and/or Chandler Dixon based on their race and/or color.
so just to make sure I heard clearly, because you're kind of quiet, that was a motion to find that there are reasonable grounds?
Yes.
Okay. And that was just the first proposed finding, is that correct?
Yes, I thought we'd take them separately, but
Sure.
I'd be happy to extend the motion to both of them if that's.
It's your motion. I just want to clarify. Is there a second for the motion to find reasonable grounds for unlawful discrimination? This is so far just for the first proposed findings.
Second.
So it's been moved and seconded. Is there any discussion? Seeing, oh, yeah.
Just one point. I just think that there are, the record is absent on just threshold factual allegations that could have been clarified with, I think, and I know that we're really burdened in terms of staff time and all those things, but I think there's some basic information that would have been available if we had inquired. And so I don't want to misstate that even chance burden again. I'll leave it to Council Archer Hirsch to fill in that blank. But I disagree with the findings of the investigator, or, yeah, thank you. I think there's not enough in the findings of the investigator.
Other discussion from commissioners? Seeing none. So the motion on the table is to find that there are reasonable grounds to believe that Lee Smith, Jane Towle, County Remax and/or LSS Holdings discriminated against Michael Stigl and/or Chandler Dixon based on their race. If you say yes, you are agreeing with that motion. Commissioner Whitworth.
No.
Commissioner David.
Yes.
Commissioner, sorry, my brain froze for a second. Commissioner Dusan.
Yes.
Commissioner O'Brien.
No.
So we have a 2-2 vote, and pursuant to the commission's procedural rule, when there's not a majority finding in favor of a reasonable grounds motion, the finding defaults to a no reasonable grounds finding. So the finding, unless someone wants to make another motion, the finding on the first proposed finding is no reasonable grounds to believe that the respondents discriminated against Mr. Stigl or Mr. Dixon based on race.
Would, Madam Executive Director, would you confirm for me that the statement of the description of policy you just made is the current policy and not the proposed?
That is, yes, I can confirm that this has been the commission's policy for about 50 years about what happens if there is a tie vote in the event that we only have 4 commissioners or someone's recused or someone's absent.
Yep.
We are, as a separate matter, proposing a different policy going forward that is not yet in place.
Thank you. I just wanted to make sure that was in the record on this case. Thank you.
Yes. So we still have the second proposed finding to address.
Well, I think they stand or fall together. I'll move that there are reasonable grounds to believe that respondents retaliated against petitioners for engaging in protected activity.
Ms. Dusan, I need to hear you.
I'll second that.
Okay, thank you. So there's a motion to find that respondents retaliated against complainants for engaging in MHRA protected activity. Is there any discussion of that motion? Seeing none. So the motion is to find reasonable grounds to believe unlawful discrimination occurred. If you say yes, you are in agreement with that motion. Commissioner Whitworth.
No.
Commissioner David.
Yes.
Commissioner Dusan.
Yes.
Thank you. Commissioner O'Brien.
No.
So again, because it's a 2-2 tie vote, there is not a majority finding in favor of a reasonable grounds holding. So the motion fails. And the default finding under current commission procedural rules is that the finding is no reasonable grounds, which means the findings on both claims are no reasonable grounds. The commission will send the parties and counsel a letter confirming that. And I thank you all for being present today. And Commissioner Whitworth, we have one case left on the hearing agenda.
Yes. Sorry, I have, let's see. One of them, are we postponing? I have 5.
We did, there was an updated agenda that I thought the current version made it to you in the what we uploaded, but there is one that was on the hearing agenda, but that has been postponed. So the next case is H/ED/PA.
Got it. Sorry about that. Adele Fagan, the trustees of St. Joseph's College. This is a recommended reasonable grounds finding. Is there anybody here for the respondent?
I think that's Ms. Bucksbaum. There you go.
Yeah, there we go. Hi, my name is Erin Bucksbaum. I'm representing College of St. Joseph.
Okay, you have 10 minutes.
Okay. Good morning, everyone. So we disagreed with the investigators' report and recommendation that there were reasonable grounds to believe that Ms. Fagan had been discriminated against because of her support animal. So our issues with the report and recommendation were a fewfold. First, the timeline and facts on which this decision were based were incorrect. The summary of facts misrepresented the situation as it was pertaining to Ms. Fagan, including her knowledge and her ability to apply correctly for a support animal at St. Joseph's College. And second, that there was inadequate opportunity for St. Joseph's to respond to some of the allegations against it. We were invited to participate in a joint session with the investigator, to which only St. Joseph's appeared at. Ms. Fagan had the ability to review and listen to the information presented by the college, but the college was not informed of her response to that information and additional allegations until after the deadline to respond to them had passed. And although we had submitted a supplemental response, we were told that it would not be considered. So with regard to the timeline, the investigators' report conflated some of the issues as it pertained to this case. So in the complaint itself focused on an event that occurred in April 2021 regarding Ms. Fagan's bringing one singular cat onto campus. Prior to that attempt, she had brought a rabbit onto campus, at which time she was informed of the policy to apply for support animals. Now, while you cannot discriminate against someone for bringing a support animal onto campus, there are concerns in a college setting, namely a shared space, that should allow some level of gatekeeping to ensure that animals brought into the dorm, A, are medically necessary, and B, have their proper vaccinations before exposing other students in a shared housing situation to that animal. And the college should be able to know what animals are living in its dorms. Now, St. Joseph's College does have a completely pet-friendly dorm, which allows students to bring animals on campus at any time for any reason. However, Ms. Fagan did not want to utilize that dorm. And during the 2020 to 2021 school year, she was living not in the animal-friendly dorm. So in the fall of 2020, Ms. Fagan was informed that if she wished to bring a support animal on campus, she would need to submit certain paperwork to this college in order to get this animal approved. She elected not to do so, and then later told the school that the rabbits were pets and not support animals that were medically necessary. In the spring, she did not notify the college that she would be bringing an animal on campus, but rather elected to sneak said animal into the dorm without permission. She did admit that she had never intended to bring a support animal on campus in the spring at all, but then circumstances necessitated her to bring the animal on campus. She was again reminded of the policy and asked to provide the proper documentation for the animal, which she did not do. Of course, then within a very short time, a week later, there was a COVID shutdown and everyone went remote off campus. Now, where the investigation becomes, I think, removed from the actual facts, during the summer, towards the end of the summer, Ms. Fagan brought not one, but 2 cats on campus, again, without submitting the proper documentation for both animals. Prior to the start of the fall semester, she filled out documentation for 1 cat, but not both cats. By October of 2021, the proper documentation had been submitted, and the college actually did approve mid-semester the second support animal. Now, while the college recognizes that more than 1 support animal may be necessary or needed, there does need to be documentation from a health professional showing a need for multiple support animals as opposed to 1, especially when they're both cats. So I think not living in a pet-friendly dorm, the college was reasonable in requesting additional documentation be submitted. During this time, there was back and forth with Ms. Fagan, where she represented both to the college that she took the cats off campus, that they were not living there, and agreed to remove them, but then would bring them back on campus, hindering essentially the college's ability to check on whether or not there were cats in the building. The college was also receiving complaints from other students. She was offered the ability to move into the completely pet-friendly dorm, which would have allowed her to continue living on campus without submitting any documentation for the animals, but she refused because she wanted to live in this particular building, which is a suite style dorm where she shares a common area with multiple other students. The investigation did find that she was constructively evicted. However, at no time was she actually forced to leave her living situation. All she was being asked to do was to comply with campus policy for filling out and providing the accurate documentation to make sure that these animals were vaccinated and medically necessary, as she was not living in a dorm that generally allowed animals. Unlike a single living situation where you're not subjecting others to animals, there should be some level of gatekeeping allowed as a reasonable accommodation for this. Now, while typically it's preferred the animals are requested prior to the start of semester, St. Joseph's did accept and approve her second support animal mid-semester in deviation even to its stated policy. The actions that were addressed by Ms. Fagan and not fully allowed to be responded to by the college, but were in part where the college had actually received complaints of odor and complaints of cats that were investigated, and upon investigating this odor complaint, found alcohol, which was against dorm code, and also Ms. Fagan is underage, which preceded some of the discipline. But it was not retaliatory or in any way. It was in response to a complaint that she was not properly caring for the animals in the dorm. So, for that reason, we do not believe that the request that Ms. Fagan comply with campus policy, of which she was well aware of, to complete the proper paperwork was discriminatory. And we'll reserve the rest of any time.
Thank you. Any commissioner questions for Ms. Bucksbaum? If so, raise your hand. Commissioner questions. Commissioner David?
Attorney Bucksbaum, is it your position that the other dorm that you call the pet-friendly dorm is the same terms, conditions, and facilities functionally as the first dorm, so that that's a reasonable accommodation? Am I understanding that argument?
Yes and no. The dorm itself is located on campus. This is a small campus, so would have been the same access to class, relatively the same quality of dorm. The only difference, of course, is that pets of all kinds, not just support animals, are allowed in the building and in the common areas of the animal-friendly dorm. She has been allowed to keep her support animals in the non-animal friendly dorm. The issue was that she had 2 animals, one of which she had submitted paperwork for and one of which she had not. And she was being asked to move into the animal friendly dorm in order to allow her to have both animals, where one of which was not properly approved as a support animal. And at multiple points, both in April of 2021 and over the summer of 2021, Ms. Fagan brought animals onto campus without first seeking approval of the college.
Okay, thank you.
Any other questions from commissioners for Ms. Bucksbaum? Seeing none.
May I ask a question?
Nope, you may not. Nope. Any other questions from commissioners for Ms. Bucksbaum? Ms. Bucksbaum, we'll have about 3 minutes when we come back to you. Ms. Fagan, you now have 10 minutes to make a presentation, but this is not for you to ask questions.
Yes, no, that was my question if I was
Okay.
going to speak. Sorry.
Yes. Yep.
Essentially, if you look in the documents that have been sent in, both applications for both animals were submitted on August 5th, which was just shy of a month before classes started, which did follow school policy. As stated by Ms. Bucksbaum, in April, I guess, of 2020, there was a circumstance that did force me, well, not necessarily force, I guess that's not the right word, but that pushed me to have my first ESA on campus. Although the difference between what Ms. Bucksbaum stated is that I was not given the opportunity to file any paperwork. I was given an ultimatum as to whether or not I wanted to stay on campus without my support animal, or I could go home with my support animal. So in that sense, it was, I felt as though I was being evicted because I was not able to enjoy my housing on campus to the fullest ability. And in addition to that, you will also find records that I have submitted to the commission, which state that I have a accommodation for a medical single. And for those of you who don't know what that means, it means that I have no direct roommate. I do live in suite style living. So in our suite, there are 7 of us total. There are 3 other bedrooms that have 2 people per bedroom. But essentially, I have my own living space where I can have, or where my ESAs do live with me. And in response to the question of the pet-friendly dorms, they do offer the same facilities. They do offer same commute to classes and whatnot. However, I made it very clear to St. Joe's that I did not feel comfortable moving because my support system is where I live. The roommates that I have chosen to live with are my support system, and my closest friends live in the floor above me and the floor below me. And I would be in a room by myself, which is different than suite style living. And I felt as though I was being isolated into that one building. And I exercised my right to ask for the accommodation into the space that I already live in. And all in all, looking over the commissioner's report or the investigator's report, there were a few things that I've highlighted, one of which I just spoke about on page 2, where the kitten was allowed to stay overnight, but I had not returned the necessary paperwork. I did present them with paperwork that night, but they did not give me the opportunity to file the paperwork with the school. That was when the ultimatum was given. I had given the information before the semester had started in the fall, which stated that I had 2 cats, and the first cat was approved, and then the second cat was not. They had asked for an additional 2 letters from my primary care physician, which asked for specific tasks that the cats provide for me, which I know is not under their, they're not legally allowed to ask those questions. I did submit those with compliance, and after they had received this 3rd letter, they had asked for medical records or the vet records for my second cat, which I complied with within 24 hours. And there was a week between the paperwork going in and the approval of the second cat, which is when that search of my suite happened. So they had all of the necessary documents. However, this process had been strung out. I think it was, if you check the records, I believe it was November 3rd that my second cat was approved. And I received, let's see. Yes, I believe it was November 2nd. My apologies. But in that process, we had that search of the suite, which they had essentially strung on the process as a form of retaliation because I had filed that complaint with the Human Rights Commission. And there were also meetings set up throughout this entire process. The first of which that we had scheduled was with the interim dean, Liz Wiesen, and the head of Res Life, Matthew Gowell. That was canceled.
If you could not use the names of those individuals.
Sorry. My apologies, won't happen again. But there was a meeting set up with those individuals, and it was canceled because of my reaching out to the Human Rights Commission. And shortly after, there was little communication. Meetings with the interim dean did happen periodically, especially when the cats were off campus. And Ms. Balksbaum is right. I did bring them on campus. However, they were outside on the grass. We have a big grass area in front of my building. So I would sit out there with leashes on them. And I was told to email her every single time that I had brought my animals on campus, even though they were not inside the buildings. And that's, I think, all I have.
Thank you. Okay, any commissioner questions for Ms. Fagan? Commissioner David.
You made reference at the beginning of your presentation, Ms. Fagan, to the first emotional support animal. Was that the rabbit?
No, my rabbit has never been registered as an emotional support animal. That was an entirely different situation. I had her on campus for a long weekend when my parents were out of town because she needed to be fed. And I explained that to residential living. And I was compliant in bringing her home. My questions with the rabbit were me more so exploring my options as to what an ESA would look like. However, down the line, I decided that because of her age, I wouldn't benefit much from having her as an emotional support animal. So I adopted a kitten for that purpose.
You were exploring your options. Is that what you just said?
Yes. So I was asking without
the permission of the university, right?
Oh, no. This wasn't when the rabbit was on campus, because I had inferred with the dean at the time, as well as the head of Res Life, to talk about the policy for emotional support animals, and said that I had interest in registering one with the school. But I never went along with that process. My rabbit is in no way an ESA, and I have never claimed that she was. So I'm thinking there might have been an issue in communication there, but that was definitely just an exploration and me better understanding what an ESA looks like.
Did you take the cats to the cafeteria?
There was one that went in. There was one occasion where the cat did go in the cafeteria, and I spoke with the dean and understood that she could not go in there. However, we were eating outside.
And was there a complaint about odor and caring for the cat?
I'm not aware. That information was not relayed to me. I'm not exactly sure how that complaint would come from anyone outside of my living accommodation, to be completely honest with you, because my room is at the end of the hall. And I also keep my room very tidy, which I have told the school. So I'm not the person to ask. I'm sure that they submitted the report from the search. I know I received a copy. I don't have it on me, but I'm not given that information. We were just told to contact the interim dean.
And I heard you say that you didn't want to move to the other dorm.
Yes.
But is it your claim that that other dorm was not a reasonable accommodation for your disability?
Yes.
And why is that? Because you didn't want to move?
No. My reason to claim that is because while I appreciate the opportunity to have pets on this campus, I think it's a wonderful thing that St. Joe's does. I stand by my cats are not pets. So they have the pet friendly dorm, but since they are ESAs under federal law, they are not considered pets. They are considered assistance animals. So for me to be secluded to one dorm, whereas all of my peers have the opportunity to pick any form of housing that they would like, I felt as though that was discriminatory.
Any other commissioner questions for Ms. Fagan? Seeing none, we'll get back to you, Ms. Fagan. You'll have about 3.5 minutes left after we hear from Ms. Buxbaum. Ms. Buxbaum, you have about 3 minutes left.
Sure, I'll respond to some of these points. First, the college does not guarantee any student particular housing. They can state their preference, but a particular dorm is never guaranteed to any student as part of the housing. So while preferences will be considered, it's not guaranteed. Second, Ms. Fagan's argument that she would have to live in a room alone seems to fall flat as it pertains to discrimination, since she has applied for and received a medical single to live in her own space. It is Ms. Fagan's suitemates that have submitted some complaints. We did submit reports, although I did redact some of the names to protect other individuals from the reports involving complaints. It is the parents and the suitemates that have issued complaints to the school about concerns regarding living with animals in a not traditionally animal-friendly building. As an educational institution, I think St. Joseph's does need to balance the ability to have support animals with students, along with concerns for the health and safety of other students, including vetting animals and allergies as well. So having some gatekeeping process is, part of allowing for these accommodations to be made. So when students are bringing pets in without informing the college and having the college react on a last minute basis without having the ability to vet any of the information or review any of the information before the animal comes on campus does pose a health and safety risk, one that I think it's reasonable that the college deals with by requiring this application process before animals come onto the campus or into a particular living situation. Had advance notice been provided, roommates could have been consulted and alternate housing arrangements could have been made for students with allergies. However, this opportunity was not presented since Ms. Fagan did not provide the requisite advanced notice. As I mentioned before, this is not an traditionally animal-friendly housing. So accommodating 2 cats without proof that both were necessary was something reasonable, a reasonable additional inquiry that the college made into Ms. Fagan's situation, especially as only 1 had been requested previously.
Thank you. Any follow-up questions for Ms. Bucksbaum from commissioners? Seeing none. Thank you. Back to Ms. Fagan. Ms. Fagan, you have about 3.5 minutes.
Thank you. As I said before, the St. Joe's was given both applications for both cats, as well as the necessary medical documentation on August 3rd. There was a, before I had my second ESA, there was an application that was submitted in regards to my first ESA, and it was sent in, I believe, on May 24th, and it was not addressed whatsoever. So I received another email, I believe on August 5th, from the head of ResLife, which was asking about the cats. And I had responded saying that I had sent in my application, but I was going to resend it. So I did update that. So they did have all necessary documentation. In addition, I did want to discuss briefly the timeline that Ms. Bucksbaum mentioned in regards to the investigation. I feel as though the timeline is very relevant because this has been an ongoing issue with St. Joe's, and it had evolved pretty severely. But all in all, I do feel that a reasonable accommodation in my situation would be just to be allowed a service animal or assistance animal. As I know, a friend of mine who graduated last year lived in a very similar living style, and he had a service dog. And in addition, my roommates prior to moving in here were all aware that I did have cats. I don't know that that's necessarily on the record, but we were, okay.
It's not, and should not be considered.
Okay, sorry, then I guess that's all I have.
Thank you. Any commissioner follow-up questions for Ms. Fagan? Seeing none. Thank you, Ms. Fagan. So at this point, we're going to turn to the investigator, Ms. Neal.
Good morning, commissioners. I'm Alice Neal. I was the investigator on this case. I want to clarify a few things and go through the timeline. I'd like to first say that I haven't heard anything from the party today that changes the recommendations that I've made in my report. I know that respondent's attorney seemed to bring up as a matter of concern that they didn't have a chance to respond to all of the information that complainant submitted as part of the close of evidence deadline. I would like to note for the commissioners today that, in fact, some of the information that I received from complainant was received before the close of evidence deadline, and that was given to respondents to be able to reply before the close of evidence deadline. What happened is the course of the investigation is that there were questions that were brought up in terms of the submissions from both parties that I needed to look into a little bit more after the record closed. I asked questions of both parties, exchanged that information, and respondent did ultimately give another untimely submission, but I did review and consider every piece of information that was given as part of my investigation. And the purpose of our close of evidence deadlines and the way that we conduct our investigations is not to allow the parties to constantly have a back and forth to be able to respond to the information that we are given, but to aid in our investigation of the matter. So it's not necessary that respondents or any party is given an opportunity on an ongoing basis to constantly provide a response. Otherwise, we'd never be able to wrap up a case and write a report. So there's that piece. I do want to make a very bright distinction in this case. I did recommend no reasonable grounds in both the education and the public accommodation discrimination claims because I didn't see anything there. So what we're really looking at and what my recommended findings are for the reasonable grounds claims are based on Ms. Fagan's housing. And the college seems to want to imply or indicate that because it is a college, it doesn't have to be held with the same standards as a routine housing provider. That is not the case. That is not the law. The college is held to housing standards as is any other housing provider in the state. And under that, they can't ask for all of the information that they asked for complainant. She gave them adequate information to be able to have assistance animals, one, plural. It doesn't matter what the breed is. It doesn't matter if they provide individual tasks. She didn't have to ask for permission before bringing them onto campus, because if you remember, an assistance animal is like having someone who needs a cane or a wheelchair or an assistive device to be able to enjoy and fully use their housing. And you don't have to ask for permission in advance. There's not some veterinary hurdle that you need to jump over or other documents that you need to give to a housing provider to have an assistance animal. And in this case, complainant gave respondent that information, gave them more than she needed to, and they kept holding her to a different standard and directing her specifically, you can have these animals, sure, but you can go live in the pet-friendly housing. Pet-friendly housing is not the purpose of a reasonable accommodation. A reasonable accommodation is a change of policy or procedure to what you have to allow someone to fully enjoy their housing. By telling complainant, you can go live in the pet-friendly dorm, they were segregating her and not allowing her to be able to use and enjoy her assistance animals in her current housing. And is just one thing to also note in terms of reasonable accommodations, it is a defense to say that there is, a health or safety risk or that an animal is going to cause some danger or damage. But those can't be based on hypotheticals. They have to be based on actual facts. So that doesn't mean that that's done. And given the opportunity of all of the current suite mates to say, oh no, we have these problems, we can't allow our suite mates to have their assistance animal. That's not a predicate. It's something that is a defense after the fact. And it's to me very important in this case for the college to recognize that they do have to treat themselves as a housing provider. They don't get separate status or credit for what they're doing with their students because they are also a housing provider. Likewise, there are many places across the country, even in the state of Maine, that have suite style housing that are not necessarily on campus, they're private entities, and these are the same juggling balances they do there. Those are very specifically housing providers. So is the college. So that's something that I think is really important to know about the reasonable accommodations piece of this, because while they said, yes, your animals are approved, they didn't actually approve them in the sense that she couldn't have them in her dorm. She was told, you can have your animals on campus, move to the pet-friendly dorm. Move to the pet-friendly dorm was then segregating her and treating her differently in the terms and conditions of her housing, to access her housing, and to be able to be there. And by telling her this is your option, they did constructively evict her from her housing. She may have remained on campus, but at least in this fall, she's remained on campus. But this past spring, she went home because she was given the choice that you can't have your assistance animal here. They didn't let her apply for the assistance animals mid-semester because it was against their policy. And so they said, you can go home. And she did voluntarily go home. But that in the sense of the denial of allowing to have the animal on campus and to be there prevented her essentially from being able to have access to her housing. And then the last piece that I want to address in terms of the retaliation claim is I'm not as concerned about the search that happened that you've heard conversation about as part of the retaliation piece. What I see is definitely that complainant filed a case here at the commission. Based on the filing of that complaint here, that respondents had taken adverse action against her. They have still prevented her from being able to have the animal and to have them on campus. And they, all of these things are in short timeline. And generally we say timing alone can't be enough. But this is such a succinct timeline, and the college knew and has been participating in this investigation while still not allowing complainant to have her second assistance animal in her dorm. And even in early November, when the record closed and they sent her a letter and email saying, your assistance animal is approved, they still said, your assistance animal is approved, move to the pet-friendly dorm. So if I sound passionate about this, it's because this was a difficult case to see that a university is trying to say we're separate and separate from regular housing. Don't treat us the same way, when that is not the case. So with that, I'm happy to answer any questions that you have.
Thank you, Alice. And Alice is right. This was, I believe, the first case we've had involving a college dorm as housing, but we've been knowing that they would come eventually. So commissioner questions for the investigator. I see Commissioner Ashby. So first Commissioner Ashby, then Commissioner David.
Hi, Alice. This is a great report. Thank you for your work in this. My question goes to the retaliation claim. If you look at the top of page 3 of your report, paragraph, the first full paragraph there, in the middle of that paragraph, in mid-September, complainant believed that since she contacted the commission and because complainant was unwilling to move to the pet-friendly dorm, she would need to relocate her assistance animals. And then if you go to all the way down to the top of page 7, in your conclusion about retaliation, you write, respondent indicated that because of the complainant, because of the commission complaint and because the complainant refused to move, she had to rehome her cats in September. There's a bit of a difference between those two statements. I'm quite a bit more inclined to find discrimination if the second of the two statements is true. Does the record reflect that the respondent said, look, you've made a complaint with the commission, you got to, while this thing all shakes out, you've got to rehome your cats in September?
There's not been that exact statement made during this case. What I can hopefully shed some light on that is that the parties had ongoing conversations after the commission's case, after the case was filed here at the commission. And the parties have consistently said, especially respondent and complainant, we're willing to do whatever the commission says. We're willing to wait on what the commission process is going to say. And so it was clear that this commission process has been pending. They're waiting to hear the outcome of it to decide which direction they're going to go. And what did happen in early September, and this is where the parties have a factual disagreement, and I'd reference footnote 6 on that, is that complainant has indicated that she was asked to sign a document after the case had been filed here that she agreed to rehome her cats in September pending the outcome of the commission's investigation. And respondent has posited that they didn't ask complainant to do that, but that she offered to do it. So there is a factual dispute between the two there. I believe that complainant has given me enough information to say that but for causation, that it still does rise to the level of MHRA retaliation for the purpose of our even chance standard.
Commissioner Ashby.
So that's helpful. Your footnote 6 is helpful then. So it may have been an organic offer on the part of complainant, but the respondent, who drafted the actual agreement, do you know?
I do not know, and I wouldn't like to suggest what that might be.
But respondent was a partner in the process of having her sign something after the complaint had been filed with the commission, was a partner in the process of having her sign something to make this agreement that while things shook out, we would rehome the cats until September, or in September.
Yes, that is correct.
That helps me. Thank you so much, Alice.
Commissioner David.
Morning, Alice. Several times in your presentation, you referred to a person's a right to her housing, and you said her housing. It seems as though you're speaking as though she has a right to that particular dormitory. Is that what you conclude?
I'm not saying she has a right to that particular dormitory. My understanding is there's a lottery system of sorts. What I'm trying to say and emphasize with that is that she doesn't have a right to a particular place. However, she does have a right to not be segregated into the pet-friendly housing because of having assistance animals. The college can't ask her to move to the pet-friendly dorm because she has assistance animals.
And that conclusion is based on what?
That conclusion is based on the fact that she's asking for a reasonable accommodation to have her assistance animals with her in her housing. And if they ask her to move to a different place and not have that conversation, they are not looking at modifying or changing their policies or practices to allow students to be able to use her housing as where she's living and enjoy it. And I say that because it's really that it's not that, you know, they can't have pet-friendly housing, but if they're asking her to move to pet-friendly housing, that's based specifically on her disability and treating her differently because of her disability.
But again, you referred to her housing as though that's her housing. Why isn't it reasonable to have isn't the analysis as to whether it's discriminatory, doesn't that have to include whether or not there's any difference in the terms and conditions and facilities between the two dorms? Seems to me it's a reasonable accommodation to the other people on campus.
And I'm certain you certainly can have that opinion and have that be as how you interpret this. But my recommendation and what the law is that complainant can't be asked to move because of having assistance animals. And in doing so, she's treated differently because of her disability if she is being asked to move to this other dorm room. And that is something
I'm going to jump in for just a second to emphasize that other people on campus are not necessarily entitled to a reasonable accommodation. A reasonable accommodation is a change in policy that is necessary to allow an individual with a disability the right to use their housing. And so this whole we need to accommodate everyone else on campus, that doesn't fit in the Maine Human Rights Act. They may want to accommodate everyone on campus as a matter of being a college and having all these students there. But for our purposes under the Maine Human Rights Act, the person entitled to a reasonable accommodation is the individual with a disability, not everyone else on campus.
Other questions for the investigator? Let me make sure, Commissioner David, are you all set?
Well, Barbara, isn't a reasonable accommodation in a same kind of facility saying move to the other dorm? Aren't the other students?
They were sending her to live in a pet-friendly dorm when she didn't have any pets. She has assistance animals. Assistance animals aren't pets. It'd be like saying she had to go live in the pet-friendly housing because she had a wheelchair. Or we have this one dorm, it's the only accessible dorm on campus, so anybody who's in a wheelchair has to live over there. But that's okay because the rooms are all nice. But
I would think it would be that she has to go live in the other, if she had a disability and needed a wheelchair, she had to go live in the dorm that had the ramps.
No,
and the
they
other
have
dorm
to put
didn't.
in a ramp so that she can be accommodated. But that's not this case. The problem is that they weren't trying, the problem, Alice's recommendation is that the problem was that they were segregating the individual with a disability. They weren't making exceptions to their policy to accommodate her. They were trying to make her fit into their pre-existing policy, which was that if you had an animal, you live over there.
Right, and because she wanted to live in a suite with 6 other people without any consideration of their allergies or their preferences.
No,
Isn't
that's
that
not
correct?
in the record, but.
Well, I thought it was. I thought that's what we were talking about.
Her preference, again, this isn't about preferences. I understand thinking that maybe this wasn't handled well all around, but for the purposes of the Maine Human Rights Act, the question is whether the individual with a disability was provided a reasonable accommodation that allowed her to use her housing.
Commissioner Doosan, I think I saw your hand up.
I'm intrigued by the concern about the reference to her housing, and I guess I want to check my understanding that Ms. Fagan was assigned to this suite style housing per the usual process for assigning students to living accommodations for the term, the semester, whatever that might be. And thus, once assigned, it is her housing in the same way that the other 6 or 7 suite mates are in their housing. Am I misunderstanding?
You are not misunderstanding that. That is exactly correct. From what I know, from what's in the record, is that there is a process that is like a lottery system. There's also seniority points and other ways that you can qualify for certain housing. And this suite mate housing is one of the, from what I've been able to tell, one of the more desirable places to live that people want to live. And so for complainant to be relocated because she was not offered a reasonable accommodation wouldn't be, yes. So the short answer is you are correct in your assertion and understanding.
Any other commissioner questions for the investigator? I would ask that we maybe save the discussion piece for now. Any other questions? Seeing none. Thank you, Alice. So we've heard from the parties and the investigator, and I would suggest that perhaps we take the 3 recommended findings individually. That's just a suggestion. It's up to you as to how you want to make your motions, but we are looking at this point for a motion or motions.
Well, I'll move that we accept the investigator's first finding that there are reasonable grounds to believe that the respondent discriminated against the complainant on the basis of disability in the terms and conditions of housing, and that portion of the complaint be conciliated in accordance with the Act.
Deb, I need to hear you.
Sorry, second.
Okay, thank you. So question number 1 on the recommendations has been moved and seconded. Motion to find reasonable grounds to believe that St. Joseph's discriminated against Ms. Fagan on the basis of disability in terms and conditions. It's been moved and seconded. Is there any discussion among commissioners? Seeing none. Okay, so if you vote yes, you are in agreement with the finding of reasonable grounds on question 1 on the recommended findings. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
No.
Commissioner Doosan.
Yes.
Commissioner O'Brien.
No.
So by a vote of 3-2, the finding is reasonable grounds on question number 1, whether there are reasonable grounds to believe that St. Joseph discriminated on the basis of disability in terms and conditions. So that's the first reasonable grounds. That is a reasonable grounds finding, and I'm just making notes on who said what to whom. Okay, Julie and Ed. Okay. So at this point, we'd be looking for another motion or motions.
I'll keep going. I'll recommend that we adopt the investigator's findings number 2, in that there are reasonable grounds to believe that the respondent retaliated against the complainant for asserting her rights under the Act, and that portion of the complaint should be conciliated in accordance with the Act.
Second.
Okay. Okay. Okay, so that is the second. There's motion to find reasonable grounds to believe St. Joe's retaliated against Ms. Fagan for asserting her MHRA rights. It's been seconded. Is there any discussion on this proposed motion? Commissioner David.
Seems to me that they continued to work with her in a reasonable way all the way through this process. I don't believe there's any retaliation at all. We can disagree about whether it's her housing as opposed to the university's housing, but I don't see that they retaliated. And I'd like one of the other commissioners to explain that to me if they want to.
Commissioner Doosan.
To the parties and skimming back through the record again, it seems that the only option offered by the school to the complainant was to move. The only accommodation, I guess, I don't know if we could call it that, was to move to pet-friendly housing. There's not the option to remain in the housing that she has been assigned with her emotional support animals. And so I view that as retaliation for asserting her rights under the Maine Human Rights Act.
Any other discussion among commissioners?
Well, I was, my questions of Alice went directly to this question, and I was satisfied with their response about whether or not the respondent had an actual hand in causing the complainant, while the commission complaint pended, to remove her assistance animals from campus. That act was wrong, but the participating in the decision to have the complainant stand down while the commission complaint pended, to me, caused the complainant to not exercise rights under the act while the commission complaint proceeded, and I think that's retaliation. And footnote 6 was helpful to clarify that, and my Alice's answers to my questions help clarify that. It's a bit confusing about whether or not it was solely a function of the complainant's belief that because the commission complaint had been filed, she had to take her animals off campus in September, or whether, as the last paragraph indicates, that the respondent indicated that that was the case. But the footnote 6 and Alice's response clarified it for me to say that the parties sort of partnered to take a stand that was probably contrary to the law, and it affected the complainant's rights adversely. And it was a function of, or solely because of, the commission complaint being filed.
What affected her rights adversely, and the commission is deciding by a 3-2 vote that it was an adverse effect on her rights, which I disagreed with. But the fact that they held that position is not a retaliation. So anyway.
Any additional discussion from commissioners on the pending motion? Seeing none. So the pending motion is to find reasonable grounds to believe that St. Joe's retaliated against Ms. Fagan for asserting MHRA rights. If you say yes, you are in agreement with that finding. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
No.
Commissioner Doosan.
Yes.
Commissioner O'Brien.
No.
So that motion passes 3-2 for a second reasonable grounds finding. And we have one proposed finding left to be addressed.
I propose that we adopt the investigator's findings that there are no reasonable grounds to believe the respondents discriminated against the complainant on the basis of disability in her education and or access to public accommodation. And that portion of the complaint be dismissed in accordance with the act.
Second.
So motion on item number 3 on the recommendations has been moved and seconded. Is there any discussion among commissioners? Commissioner David?
How can it not be, given our other 2 decisions, how can it not be a discrimination in regards to her access to her housing? How is that consistent?
It's actually not. So the proposed motion is solely related to education or public accommodations. It separates out the housing piece, which was already decided.
I don't understand the distinction between housing and public accommodation. I understand. You mean not discriminating in regards to her education is sufficient to say there's either one of those?
So the definitions by statute of a public accommodation is a place or service that's open to the public, which is perhaps distinct, as we're deciding, as Alice has recommended finding in this case, that the housing service that's being offered is not open to the public. That's different than the public accommodation services the college might offer or education services that the college might offer.
Got it. That's very instructive. Thank you very much. Now I understand.
Any other discussion among commissioners of the pending motion? Seeing none. So the motion is to find no reasonable grounds to believe that St. Joe's discriminated against Ms. Fagan in education or public accommodations. If you say yes, you're in agreement with that. Commissioner Whitworth?
Yes.
Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner Doosan?
Yes.
Gotta see your hand.
Yes.
Thank you. Commissioner O'Brien?
Yes.
Thank you. So that finding is no reasonable grounds. So just to recap, we have 2 reasonable grounds findings and 1 no reasonable grounds findings. The commissioners will send a letter to parties and attorneys to confirm that finding and discuss the next step in our process. We thank you both for being present. Thank you. That's the end of our hearing agenda. So at this point, we would be looking for a motion to go into executive session unless the commissioners want to take a break for a couple minutes, but otherwise, nope, I see a few yeses. Yeah. Commissioner
Yeah,
Bailey.
no, I'm not asking for a break. I'd like to get it done before lunch. I was concerned about, I wanted to ask you about this 5th case. Did I miss something? I
Yeah.
only had 4 cases I was reading, and I want to read the case if I'm supposed to have been up on it, even though it's
Nope.
continued.
Nope, you did exactly the right thing. I had sent, I think, a previous version of the agenda to the commissioners by email, perhaps, that had 5 cases on the hearing agenda. But then when we uploaded your materials, there were only 4 cases to be heard because we have tabled 1 case. So you haven't missed anything.
I did what Melody told me to do when she uploaded them, right?
Always a good thing to do. So
Pursuant
people,
to
go ahead.
Pursuant to 1 MRS Section 405 6E, I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
If I could just interrupt for a second. Commissioner Whitworth has asked for 5 minutes. So I think it would be good for all of us to respect each other's need for a break. I don't know, technically, can we leave the motion pending? And then, no. So do we need him to withdraw it?
He can withdraw it, or we can
Yes.
vote
There
and then
wasn't a
take a
second.
break while we're in executive session.
Oh,
Wasn't
can we
a
do that?
second.
Oh,
Why couldn't we?
okay. All right, cool. So,
Wasn't a second.
all right, Jill seconded.
No,
All
I
those
did
in-
not.
You
I
did not.
There
I'm
was
sorry.
not a second of the motion is what I'm saying.
Has
Oh, well,
anyone,
then it's not pending and we can take a break. Thank you,
Dying for a
Jill.
lack of a second.
okay, so
Everyone
Jeff,
take 5. Come back.
Jeff will be right back. Okay, 5 minutes. have once again muted myself. We're just waiting for Jill to come back. Okay, Mr. Ashby, would you like to repeat your previous motion?
I don't think you should phrase it that way, but I will repeat my motion. Pursuant to 1 MRS section 405(6)(e), I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
Second.
All right, wait, and all commissioners, oh, I have to ask you one by one. Commissioner, the motion is to go into executive session. If you say yes, you're in agreement with that. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Doosan.
Yes.
Got to see your hand. Thank you. Commissioner O'Brien.
Yes.
Thank you very much. The motion passes. I am going to, it's going to take me a second because I did not add everybody. Hold on.
Thought we already were. Isn't this just?
No, we're
us?
not
No?
there yet. Nope, we're going to go into executive session now. You will be magically transported. Okay. Oh, Bob is still here. Okay. Wait, let me make sure are we missing a commissioner? We're missing Deb. I keep saying that, but this time we're actually missing Deb. Hold on, Ed. Hold. All right, there we all are. Okay, Ed.
I move that we not litigate E20-0381 Boyer versus Welch, and that we not litigate E20-0493 Holcomb versus Grant.
Do you want to just wrap all of it into your motion?
Well, I don't think, do you have to move that we litigate the ones that we have to
Yes.
litigate? We have to
Yes,
litigate.
we
them.
do. Nope, but we
Okay.
have to, yep.
Then I'll add to the motion that we litigate H20-0085 and H21-0188. And I didn't write down the names of those two.
I will fill them in there, Janelle and McGuire. Is there a second?
Second.
Many seconds. Excellent. Okay. So once again, I will take you one by one. If you're in favor of not filing the 2 employment cases and filing the 2 housing cases, that we will fill in the case names and numbers. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Doosan,
Yes.
Commissioner O'Brien.
Yes.
Excellent. I believe that's all we need, and it's 12:02.
Thank you, everybody. Have a good day.
Thank you. See you all in February.
Enjoy the weather, Barbara.